Gopinath Mitra for the
May I please approach?
Mr.
May I please?
Yes, madam.
Your Lordship, I am.
You're Miss Jajodia.
Your Lordship, my name is S. Senapati.
Miss S. Senapati for the Soumya.
Shweta Senapati.
Shweta Senapati. Sorry. Yes, what do you want, Miss Senapati?
Your Lordship, in this instant matter, I filed this present application for the enhancement.
The first matter is of your senior.
Yes, Your Lordship.
Kariba to?
Again.
Take your seat. Listen to him. What is?
Yes,
please.
125 order is under challenge.
Yes.
I am the husband. I have filed this RPFM for annulment of the maintenance order.
Yes.
And the other one, she has filed for enhancement.
What is the award amount?
20,000 per month from the date of application.
As per your instruction.
But my instruction is, she is not entitled to any maintenance because she is.
Sir, his perception cannot override a judicial pronouncement.
That is there.
My difficulty is that I have, I'm yet to find anyone liking to pay. Whatever little, definitely less experience than you in these kind of matters. Everyone has a rate, has a difficulty. But what can be done? It is Article 15(3), which the young lawyer must understand. This is Article 15(3) of Constitution of India.
Yes.
Rajneesh versus Neha, Justice Chief Justice Deepak Mishra judgment. This is the only way the law has been made to a certain extent to ameliorate the condition. So what was the material? Then we have to go to the evidence led by the present petitioner in your case. Your client. That the court would reject amount.
Yes.
And gradually the law has shifted. Initially it was husband-wife. Now you see domestic violence.
Others are also.
125 parents. Since we are taking
evolution,
so many matters, parents are also coming.
Evolution.
One of the secretaries was typing said, nowadays parents have to come to court to the. This is what they discussed among. That's a common perception. My point is to share with you is that this is a societal problem also. So when we are seeking legal answers, strict legal answers are not possible.
Evolutions in favor of the ladies, that is 15(3) what your lordship pointed out.
No. 24-25 is gender neutral. Even if 15(3) is earlier, 15(3) since the Constitution was enacted, it's not an introduction. Women and children.
Yes.
125 you can find. 125 parents were there. Now domestic violence in the relationships.
One thing.
Also Rajneesh versus Neha has discussed that.
One thing
my friend agreeing staying together for a long time, they can file 125 or domestic violence. Financial assistance. In fact, they have changed the term.
Financial assistance
is now been replaced by the legislature.
Financial assistance.
So you have worked out these matters. So the whole effort is that you work on this, you come back.
Yes, my lord. My one submission, if my friend agrees.
No. Then you have to hear her. Because she is now, subdued in your presence and my address to you. We have to hear her.
No, she is equally competent.
Definitely. They have to be encouraged.
Yes.
I was just, in fact, that is the reason I drew her attention that whether she has thought about 15(3), how 15(3) is reflected in 125, how the court has,
if it can be,
what I am saying is not for the first time, or I have not, it is not my what I have read, I am sharing with you.
If it can be referred to mediation, because parties
mediation, I am a little bit reluctant to refer because non-compliance of a decree and sending for mediation creates a bad precedence. And of course, we were hearing Honorable Justice Bikram Nath, because we are also under this kind of evolution. There is a standard practice to defer because once we send it to the mediation, obviously we have to stay the decree. Otherwise, the parties will be at
execution has not started, and correct. So is an engineer with an MBA degree.
So yesterday the argument is not yesterday for the last over a month a matter has been argued regarding a sub-inspector. The allegation against the husband is he has entered into another relationship respect to the court's decree. And we are really pressurizing to the court's decree. And we are really pressurizing the courts to dispose of these matters. Tendency and explosion of matrimonial matters is one aspect. Recent last week or week before that, one matter the Honorable Apex Court have granted 142 irretrievable broken down, 44 cases against each other. The observation of the court is you have choked the system.
Yes.
Those who are hyperactive, why the reason that old matters in this determination are not being listed? They also lose steam and they don't pursue. But initially, some litigants are hyperactive. They are hyperactive. Societal. This is societal issues.
Yes.
It is so easy to tell that they are being guided by lawyers to launch as many cases. Yesterday, the father-in-law is 70, mother-in-law 60. Domestic violence transfer. Both are after death of the husband, death of their son. They are facing domestic violence case. This is
As you found the Ainiro.
We should try to amicably settle the matter, and if we could reach at a middle ground, we should try to amicably settle the matter, and if we could reach at a middle ground.
so. I have requested Mr. Mishra, though it is beyond his brief, but he will persuade the husband in the marriage to deposit some amount.
Indeed, Your Lordship.
Okay, but I am not recording that.
Indeed, Your Lordship.
Gopinath Mishra first matter jaka बीच जाकर समान कर देंगे ता तोड़ के लिखिबे मिस एस सेनापति 192 रे मिस्टर मिश्रा 376 रे so miss other part Mr. Mishra, I was actually impressed with your effort in that MATA matter where you suggested that he will pay 10 lakhs.
Yes, and we are
but there the wife did not agree.
Yes. Still we are in the process.
So, that kind of effort you should make in all cases.
Yes.
So definitely it will be time consuming for no purpose of your personal, professional business.
No, but
you please contribute.
I have some duty towards this.
But that you did a phenomenal work. Looking at the person, the way he was behaving and talking, but he could, of course, he gradually had a faith in the system. We also took note of it, so that. But still, I think hopefully the two children, they are grown up.
Now the children have come forward for a settlement to make an amicable settlement between parents.
So that is you're partly persuaded by court, but you had, that is in division bench.
Yes.
Second matter, RPFM 364 is Mr. Senapati for the petitioner, Mr. Gopinath Mishra for the RPFM, order RPFM 192 of, kindly take your seat. I'll take some time, 2-3 minutes I have to take. RPFM 192 has been filed by the husband in the marriage under section 442 of BNSS, all capital. Read with section 19 into bracket 4 of Family Courts Act. Challenging order dated 18/4/2023, passed by the learned judge, Family Court Hon'Ble, in C.F.P. case number 03 of 2022. By the said judgment, the petition filed under section 125 of CRPC into bracket since repealed and substituted by BNSS. Bracket close. Filed by filed by the wife in the marriage. Right. The wife had sought for a maintenance of rupees 35,000 per month. The Honorable Judge Family Court has ordered rupees 20,000 per month as maintenance to be paid by the petitioner husband in the marriage. The RPFM 376 of 2025, which has been listed together as directed earlier, has been filed by the wife seeking enhancement of maintenance granted. Stop. The learned counsel for the petitioner husband was heard at some length. And so also the learned counsel for the petitioner wife in the other RPFL having stopped. Para having heard learned counsel for the parties. It emanates that there is possibility of reconciliation between the parties. Though that would not be a ground not to entertain both the RPFMs and the claims made therein. Stop. The learned counsel are requested to work for a acceptable solution for both the parties. The learned counsel for the husband shall also obtain instruction regarding the amount of maintenance that can be paid during pendency of the petitions. List in the week commencing. So 16 20 chums. Yes, next.
Item 2.
Much obliged, Your Worship.
Please, one thing, this is a little bit tricky because they are of same age. Because I mean, so you have to be, you have to be more persuasive.
Yes, we shall try.
Niranjan Singh for the.
My lord. This is an application filed by the husband against the order of Judge Family Court Hon'Ble in Section 24 of the Indian Marriage Act. On last occasion, your lordship had
To the microphone, sir. Take a microphone report.
in this case,
I got it.
my
Then you said something, I just missed it. Section 24 has been filed by husband, that has been rejected.
no, two petition was filed, one husband was filed and another wife was filed, and in that
Both filed section 24 against each other.
But in this case, try
Sorry, against claiming
claiming each other, man.
claiming 24 maintenance pending legs from each other. Right?
And in that case, the learned family court allowed the petition in favor of the wife and also the children. I have challenged that part. In section 24, there is no
Children you will not give.
no. In section
Children you will not give money.
not give money under section 24. Under section 24, there,
Apura 42 रे देवे ना तू.
no.
अब बात थिले बोधे कोर्ट रे ଆମେ ତ ସବୁ ଆପଣ ଆଉ ଥରେ ସେ ଡିସ୍କସନ ଚାଲିବ. ଆପଣ ୱାଇଫ କର ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଠିକ ଅଛି ବଟ ଚିଲଡ୍ରେନ କର କୋ ପ୍ରୋଭିଜନ ରେ ଚ୍ୟାଲେଞ୍ଜ କରିବେ.
Section is
ତାପରେ ଚିଲଡ୍ରେନ ତ ମାଇନର.
minor, admit my lord. It is
ଆପଣ
admit,
ବୁଝି
but
ପାରୁନାହାନ୍ତି.
sir,
ସାର୍ ଏଗେନ୍ ଆପଣଙ୍କ ସେଦିନ ଯୋଉଟା ଶୁଣି ସେଥିରେ ଗୋଟେ ଆଡଭାଣ୍ଟେଜ ଥିଲା ଯେ ଆପଣ ଶୁଣିକି ବି ନ ଶୁଣିଲା ଭଳିଆ ହଉଥିଲେ. ଆପଣଙ୍କର 24 ରେ ଏକ୍ସପେନ୍ସେସ୍ ଅଫ ଚାଇଲ୍ଡ ଇଜ ଏ ଫ୍ୟାକ୍ଟର. Yesterday again same, it is not Kesavananda Bharati. Sir, 24 रे जदि wife is having the custody, then children को पाई mother being the natural guardian, she is entitled to spend for that. ଆପଣ କୋଉ ଗ୍ରାଉଣ୍ଡ ରେ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ସେଟା ସେକ୍ସନ 24 ରେ ନୋ ବୋଲି ଯଦି କହିବେ କେମିତି ହେବ? ଇଟ୍ ହାଜ ଟୁ ବି ଡିସମିସ୍ଡ.
Section 20 kindly have a glance to
ଆପଣ 24 ରେ କେତେଟା କେସ୍ ଲ ପଢିଛନ୍ତି ଯୋଉଥିରେ କହିଛି ଯେ ଚିଲଡ୍ରେନ କୁ ଦେଇ ହେବନି ବୋଲି? ଆପଣଙ୍କର ବେଷ୍ଟ ଡିସିଜନ ଟା କହିବେ ନା ଆଉ.
ହଁ ସାର୍ ଦଉଛି
ଆଉ କୋଉ ପାରାରେ କହିଲେ ଯେ ଚିଲଡ୍ରେନ କୁ ଦେଇ ହେବନି ବୋଲି? ଷ୍ଟେଟ ପଢନ୍ତୁ. ହଁ ସାର୍ କହିଲେ କଣ ହବ? ଆପଣ ତ ପଢିବେନି, ମତେ ରିକ୍ୱେଷ୍ଟ କରିବାକୁ ପଡିବ. वी आर ସ୍ପେଣ୍ଡିଂ ଟାଇମ ଇନ what the state କହିବେ ଯେ ସୁପ୍ରିମ କୋର୍ଟ ମନା କଲେ ଏଇ ଡିସିଜନ ରେ ଯେ ଚିଲଡ୍ରେନ କୁ ଦେଇ ହେବନି ବୋଲି. ଷ୍ଟେଟ
ପୁରୁଷ ଆନେକ୍ସର 4 ପେଜ 51 ମୁଁ ଦେଇଥିଲି ସେଟା ଯେ ପୁରୁଷୋତ୍ତମ ଦାସ ଅଗ୍ରୱାଲ
अरे ଆପଣ ପଇସା नहीं. This decision Supreme Court has said, give the citation that the children are not entitled for any money to under 24 cannot be.
of our
High Court କେମିତି follow କରିବି? Maintenance for the expenses maintenance in 24 while considering 24.
then in section 24 there is no such provision my lord to
अरे ସେଇଟା ଆପଣ ମତେ 10 ଥର 20 ଥର କୁହନ୍ତୁନି. ଆପଣ ତ because of your lack of reading I should not spend time. ଆପଣ ଯଦି ପଢିବେନି ସେଇଟା କେମିତି ହବ? ସେ ବାକ୍ୟଟା କଣ ହେଲା? କଣ ସେଗୁଡାକୁ ତାସ ଭଳିଆ ଫେଟୁଛନ୍ତି ନା କଣ?
year 1982 ओडिशा 270
ସୁପ୍ରିମ କୋର୍ଟ ସାର୍, ଓଡିଶା ସୁପ୍ରିମ କୋର୍ଟ ହେଇନି, ସେଟା ଥିଲା ମାଡ୍ରାସ ସୁପ୍ରିମ କୋର୍ଟ ଥିଲା.
but I have not got any supreme decision I have got
ସାର୍ 82 କୋଉଟା ରିଲାଏ କଲେ?
it is 82 relax on the
ସୁପ୍ରିମ କୋର୍ଟ ଡିସିସନ ଉପରେ ସେଟା ତ ଦେଖିବେ
82 ओडिशा रे सुप्रीम कोर्ट डिसीजन रिलाइज
କେମିତି ହବ ତାହେଲେ ସାର୍?
इट इज
82 ରେ ଯାହା ଥିଲା ଆକ୍ଟ ବର୍ତ୍ତମାନ ବି ସେୟା ଅଛି. 53 ଆକ୍ଟ କିଛି ଚେଞ୍ଜ ହେଇନି. 24 ରେ ଦେଇଛନ୍ତି ବୋଲି ଯୋଉ କହିଲେ କହିଲେ ସେଟା ଟିକେ କୋଉ ଯୋଉ
in pending action under section 13 of the Hindu Marriage Act by the husband against wife and application under section
କହିଲେ ପଢନ୍ତୁ. ଆପଣ କଣ ମିଶେଇ ଦଉଛନ୍ତି ସବୁ? ବସ୍ କିଛି ନୁହଁ, ସବୁ ୱାର୍ଡ ମିଶିଗଲେ କେମିତି ହବ?
in a pending action under section 13 of the Hindu Marriage Act by the husband against wife an application under section 24 of the act was made asking for interim maintenance as also litigation expenses by the imperial order dated 13/1981. The learned subordinate judge has directed that maintenance for the wife should be at the rate of rupees 150 per month.
କଣ ପଢୁଛନ୍ତି ସାର୍ ଆପଣ? ହ୍ୟାକ୍ କଣ ପଢୁଛନ୍ତି? ଏଇଟା ବି କମ୍ପ୍ୟୁଟର ଡିସିସନ.
ସାର୍ ସେଇଟା ତାର ଦି ଲାଇନ୍ ପରେ ଆସୁଛି ସାର୍.
ଦିଲାନ ସିଧା ପଢନ୍ତୁ ସେଠି, ତାପରେ ପଢନ୍ତୁ କ୍ୱିକ୍.
Mr. Murthy appearing for the petition contains that an application under section 24 of the act maintenance for the child is not contemplated and he also relies on the factor of that child here is said to be not born out of the Wedlock. He also contends that the expenses of rupees 500 as awarded excessive. So far as the first contention is concerned, I would agree the award of maintenance for the child is not within the purview of section 24 of the act.
ମାନେ କାଉଥିରେ ପଡିଲେ ଗେଦେରି ଦେଲେ ସେଠି
ନାଇଁ, so far as the,
ସବମିଶନ କରୁଛନ୍ତି
no,
କୋର୍ଟରେ ଆପଣ ଦିଅନ୍ତୁ ଦୃଶ୍ୟଟା ମୁଁ ଆପଣ ବହୁତ ସମୟ ନେଉଛି ମତେ ଦିଅନ୍ତୁ ବହି ଆଣିଛନ୍ତି ନା ବହି ଆଣିନାହାନ୍ତି
paragraph, ଆଣୁଛି ଆଜ୍ଞା,
ହଁ ବହିଟା ପଢନ୍ତୁ ଅବଜେକ୍ସନ ରିଜନ୍ସ ଟା ପଢନ୍ତୁ
section 24 ନା।
24 ଅବଜେକ୍ସନ ରିଜନ୍ସ ପଢନ୍ତୁ
Wherein any proceeding under this act, it appears to the
ଏଇଟା ରଙ୍ଗ ଡିସିସନ ପଢନ୍ତୁ ଏଇଟା ପଢନ୍ତୁ ବୁଝିପାରିବେ କୋଉଠି ଭୁଲ ହେଇଗଲା ଅବଜେକ୍ସନ ରିଜନ୍ସ ଟା ପଢନ୍ତୁ
wherein any proceeding under this act, it appears to the court that
ଆରେ ଅବଜେକ୍ସନ ରିଜନ୍ସ କହିଲେ ସେକ୍ସନ ପଢୁଛନ୍ତି ଛାଡ଼ନ୍ତୁ ହବନି ମତେ ଛାଡ଼ନ୍ତୁ ମୁଁ ପଢେ ପ୍ରୋଭାଇଡ ପଢିଲେ 24 ର
provided that the application for the payment of the expenses of the proceeding and such monthly such during the proceeding shall as far as possible be disposed of within 60 days from the date of service of notice on the wife or the husband as the case may be.
ତାପରେ ଅବଜେକ୍ସନ ରିଜନ୍ସ ଲାଷ୍ଟ ଲାଇନରେ ଦେଖନ୍ତୁ ଅଛି with a view to making provision that an application for alimony parental right or the maintenance and education of minor children shall be disposed of within 60 days.
Nine.
That's the problem. Upon ଯେତେବେଳେ ଯିଏ କୋର୍ଟରେ ପ୍ଲେସ୍ କଲେ and this is a bench one of the greatest India has produced. The lawyer has not assisted properly. What do you mean by maintenance? Expenses, what do you mean by that?
Lordship,
So you should not.
your lordship can take up the other.
It has to be referred. No, you are not preparing, sir.
Your lordship.
You make a then and read this para 3 of this judgment of Supreme Court. You should not get it. Kuade gola pacharu.
We are constrained to observe that this order shows total non-application of mind on the part of the
ଆପଣ ମାଇକ୍ରୋଫୋନ ଦିଅନ୍ତୁ ସେ କଣ ଜାକି ଜାକି ପଢୁଛନ୍ତି you chew pan or what
paragraph 3 man.
ଆପଣ ପାନ ଖାଆନ୍ତି କି ନା କଣ
ନା
ଆଚ୍ଛା ଠିକ ଅଛି ଆପଣ ପଢିଲା ବେଳେ why you are chewing the words what you are reading is not odd there maybe this barrier is a problem yes next ପଢନ୍ତୁ
we are constrained to observe that this order shows total non-application of mind on the part of the High Court. This was a case where maintenance had been granted to a wife and to a minor son. The High Court, without recording any reason whatsoever, has stayed the grant of maintenance both to the wife and to the minor son. This should not be done. A husband, a father is duty bound to maintain his wife and child. Unless there are very special reasons, the higher court should not.
you ପଢିଲେ ଛାଡିଦେଲେ ସେଟା is duty bound to
Is duty bound to maintain his wife and child.
ଦିଅନ୍ତୁ is a decision in 125, but this duty is emanates from the so 24. How can a court will exclude the child because the child is a child? In fact, the problem is, I mean, that's a very, I mean, it has a consequence. Suppose now I take a view, I agree with that 24 child's maintenance could not be, you on your own swing, you say that the child is with the mother.
Yes, ma'am. Yes, ma'am.
So then the whole legislative intent is frustrated and also lead Rajesh versus Neha.
But this in section 24 say that
ଆପଣ ଯଦି ଆପଣଙ୍କ ପ୍ରୋବ୍ଲେମ ହେଲା ଯେ 82 ରେ ହାଇକୋର୍ଟ ଡିସିସନ ପଢିଲେ now 44 years have passed, you are not looking at the law, not looking at the section objects and reasons of section 24.
Lordship may take another, but my
No, sir, me taking up, this is the third time, we are arguing this matter.
No, the matter was here, ma'am. Your Lordship on last occasion, your Lordship.
2026, 31, 2026, last time you were appearing in full.
Ask the question whether the REIT is maintainable or not. That is the question was on last 2 days.
Sir, no. You can take the YouTube video. This is recorded, this is live.
Yes.
So when you are saying something, that Lordship asked this question, so that's a different thing. You chose to appear and not to hear, so that you cannot hear anything from the court. That day,
Last
ଆପଣ ଭିଡିଓରେ ଆପଣ ଶୁଭୁନଥିଲା.
again.
That is a purpose in recording everything in the order.
Again.
It is submitted by the learned कौन लिखले? I'll take 2 minutes. Take your seat. Appearance लिखले. So Niranjan Singh for the petitioner, opposite party. Blank. The petitioner wife in the marriage, the petitioner husband in the marriage is before this court. Challenging the judgment dated 13/3/2024. Passed in CP number 19 of 2023. 19th call लिखिए CP number 19 of 2023 by the lauded judge Hon'Ble Court Hon'Ble.
A number now is 30/24.
ऊपर लिखिए आईए टा लिखिए challenging the judgment dated 2/2025 02.08.2025. When I am in control of the things, don't interrupt. They make a mistake. They can't. Human being cannot take 2 dictations.
No, number टा भूल गया
Number भूल है नहीं. Number ठीक है जी. आईए टा insert होता है तेरे. आईए arising out of which CP? CP
49.
Who had filed section 9? Section 9 किए फाइल करते हैं.
Section of husband file करते हैं.
48 टा किए फाइल करते हैं.
48 भी husband file करते हैं.
13 दे.
13.
ठीक है जी. कौन लिखे? The order judgment dated 2/8/2025 arising out of past in judgment dated past in IA number 13 of 2024, IA number 13 of 2024, past in IA लिखले arising out of CP number 48 of 2024. The said IA was filed by the petitioner wife who is the opposite party in the CP, along with the 2 minor children, which is about 9 years and 5 years. Respect 2 minor children. Daughter is it about 9 years and son is it about 5 years. Seeking maintenance under section 24 of the Hindu Marriage Act. The learned counsel for the petitioner relies on the brief order passed by the coordinate bench in Purushottam Das Agarwala versus Srimati Pushpa Dedi, dated 26/2/1982, कॉलम दे की साइटेशन दे देवे AR 1982 ORI 270 Odisha. He relies on the paragraph 2 of the said order of the coordinate bench at page 51. The counsel is requested to refer to any Supreme Court, refer to any decision rendered by the apex court regarding interpretation of section 24, as has been made by the coordinate bench. Candidly, he submits that he has not examined that aspect and seeks further time. The learned counsel, this court notices the objects and reasons of reviso to section 24. This court also notices the decision rendered by the apex court in Rajnesh RAJ NESH versus NEHA Neha. Citation दे देगा देखिए para 92, 93, para 130. As the matter stands adjourned to be taken up in the week commencing. Mr. Singh, do some research, Mr. Singh. The first thing is that you have done a good thing, that you have got a decision directly on the point, but no discussion. Why the court said so 24, and you have not examined further for the last 44 years. So, and if there is a Supreme Court decision, then the High Court decision is binding or not?
Not bad.
Not binding. I cannot ignore the Supreme Court decision.
Put a subtype.
Is in the week commencing? Not in na nahi 23.
Please.
23. Yes. They have filed execution.
No, not really.
Yes, next.
Item 3,
So Vishwambar Mahanti for the petitioner.
May I please, Lordship?
Yes, please.
That is, my lord, the order passed by the permanent or local authority under Section 5.
So have you satisfied Jalor Singh?
Hello?
Jalor Singh and Bhargavi Construction, they say, for challenging a order passed by the permanent local adalat, you have to follow the particular procedure declared by the Supreme Court.
I have not gone.
So please check it.
I have not.
The petitioner. You take your seat. I'll take 1 minute. The petitioner is before this court challenging the award dated 28/11/2025, passed in PLA case number 48 of 2025 by the learned permanent local adalat, Puri. Para. Learned counsel for the petitioner has adjournment to apprise this court as to whether the petitioner in order to challenge the order passed by the learned permanent local adalat has followed the procedure and remedy as laid down in Jalor Singh, as laid down by the FX court, by the Honorable Supreme Court in Jalor Singh. Into bracket Constitution bench. State of Punjab versus Jalor Singh लिखते State of Punjab versus JALOE versus into bracket 2008 bracket close to SCC 660. The said principles have also been reiterated by the subsequent two-judge bench. Subsequently by a two-judge bench in Bhargavi Construction. Pura citation, that is. Mahanti, you are not expected. Knowing you at the bar, you are not expected that you will not take that. Busy haba ebong somoy nai boli ta gote ame samaste kohu, but we have no choice. Once a student of law, always a student of law. Yes, next.
Your Lordship, call
Maintainability is not an issue. Perhaps when I am saying this, everyone is addressing me whether REIT is maintainable. REIT is maintainable. That's the only 223, 227 is the only option. But for following 226, you have to follow a Jalor Singh 142 guideline.
I have to go through that, my lord. 2008 volume 4 SCC 660, your Lordship. The first judgment.
2008 volume 2 करी ना, वो 6 लिख ली.
Madam.
Speak. Yeah, 2008 Supreme Court 1209.
Only the writ is maintainable because the act says that cannot be challenged in any forum, either the suit or any proceeding.
No, no. Maintainability is not at all an issue.
My lord.
Even if you say it's not, the other side will argue not maintainable. Answer is definitely maintainable.
Maintainable, my lord. Because I have gone through that.
There is a finality as such.
On the legal, on the legal service of
but I mean, on the limit grounds, you have to say, and whatever. If we make the starting point, that's the starting point, then it becomes easier for you, also for me.
Let it come 2 weeks after.
नहीं ठीक अच्छी पर देखो the reason being that there is a avowed objective because the local matters are decided upon consent of the parties.
No, my lord.
So, unlike the parties they reopen, and the usual plea is that I did not know.
My lord, that is regarding.
Then suppose you say there is fraud, force, duress. Usual free consent is hit by fraud, force, duress.
Yes, the matter.
So those grounds, whether you have to, how you have to argue that, how you will place that before the court, so all those things.
Because that regarding the just I'm online adding that regarding the local, here the permanent of the local
2008 to SCC 660.
under section 22C.
ଆପଣଙ୍କ citation ଆମକୁ ଟିକେ ନିଅନ୍ତୁ ଆଗ
লিখি ଦେଇଛି
ସେଟା ବି ମତେ ବି ଦେବି ତାପରେ ଆପଣ ତାକୁ ସ୍କ୍ରାପ କରିଦେବେ
2008
8 to SCC 660
ଆଜ୍ଞା
ଜେଲର ସିଂ ଠିକ ଅଛି ଆଚ୍ଛା ଆପଣଙ୍କୁ ଡାକି ନଥିଲି I did not dictate him. Yes, next. କଣ କହୁଥିଲେ?
ସେଥିରେ ୟାଦେରେ section 22 supply.
Sir, you are arguing that REIT is maintainable or not.
No, what your
It is saying that, so you read Jalor Singh,
My lord.
what it says, you may argue that it is not applicable. So I have no difficulty.
Then I am not saying
So you
What
please
is law?
examine that.
my lord.
Because once that benchmark is crossed, it becomes easier for us. Threshold, you can say, not benchmark, threshold.
Let it come 2 weeks after. My lord.
Yes.
Last official.
Least in the week commencing, 23 ना मार्च नेक्स्ट तापर वीक रे
23 ରେ था
ठीक ଅଛି ତାହେଲେ 23 କେ नहीं 23 ଆପଣ ଫେବ୍ରୁଆରୀ କହୁଛନ୍ତି ନା ମାର୍ଚ୍ଚ
7 ଫେବୃଆରୀ
ଫେବ୍ରୁଆରୀ ହେଲେ ତାହେଲେ 2 ମାର୍ଚ୍ଚ 2 କମେନ୍ସିଂ 9 ମାର୍ଚ୍ଚ ରଖନ୍ତୁ 2 ତାରିଖ ଛୁଟି 2 3 4 ଛୁଟି ଅଛି ସୋ 2 ତାରିଖ ଟା ଆପଣ ଜାଣିଥିବେ ଏବେ କିଛି ନାହାନ୍ତି କି
ନା
ଆଚ୍ଛା କର୍ମକର୍ତ୍ତା ଆପଣ ନୁହନ୍ତି ଏବେ
କେବେ ବି ନଥିଲି
ଆପଣ ଥିଲେ
ମଝିରେ
ସେଇଟା ଆପଣଙ୍କର ନାଁ ଜଣା ପଡିଲାନି ସମସ୍ତେ ଖୋଜିଲେ ଆପଣଙ୍କ ନାଁ ପାଇଲେନି
ପାଇଲେନି ଏଭରିବଡି ନୋ ପିଣ୍ଟୁ ବୋଲି ଆଉ ବିଶ୍ୱମ୍ବର
ସେଟା ଜାଣି କହୁନି ଆପଣ ଗୋଟେ ଆଫିଡେଭିଟ୍ କଣ କରିକି ହେଇପାରିବ ପରା ପିଣ୍ଟୁ ବାବୁ କରିଦେବେ
ହେଇପାରିଲାନି ସାର୍ ଥିଲେ ଇଲେକ୍ସନ ଅଫିସର ଆଇ ହାଭ୍ ରିକ୍ୱେଷ୍ଟେଡ ହିମ୍ ସେ ମନା କଲେ
Order of the learned court below in execution under Annexure 4. Well, sir, the execution proceedings, the learned court below had, on the consent of both the parties, had devised a mode of recovery of the area maintenance from July 2019 to September 2023 by way of installments. So that order, my lords, is at page 22. Order dated 22/7/2024. That's the page 23 is the operative portion, my lords. In course of hearing, it is submitted by learned counsel for the opposite party that he is willing to pay the balance area maintenance dues of rupees 7,60,000 to the petitioner in suitable installments at the rate of rupees 15,000 for each month. The learned counsel of the petitioner has submitted that the petitioners have consented to the said installment basis payment towards payment of their balance area maintenance dues. On consideration of memo of the opposite party, the approval signature of the petitioner on the said memo of the opposite party, and the submission of learned counsel for both the parties, it is considered to be just and proper to allow the opposite party to pay the balance area maintenance dues of 7,60,000 in 52 installments, out of which 51 number of installments to be paid at rupees 15,000 for each installment, and the last 52nd installment will be of rupees 3,000. The opposite party is directed to pay each installment within 1 week of the month, put up on 29/8/2024 for payment of area maintenance due as per installments. Because after this,
into 724 तो
sure 27/24.
तो 1 year and 6 months 8 months 6 months right so why the challenge now sir because you want it at a time or what
I have paid according to this installment. Now, that she had filed an application for attachment of my salary. So the learned court below has allowed in the impugned order under
So
annexure.
why you have filed a written statement for in the prior to the attachment of salary? That you have to show. Have you read the decision on this?
It's,
RPFM, the scope of revisional court. Have you read it? So you have to tell me.
Minutes.
I have, and I will also. I mean, no hesitation there.
Minutes.
I'll be happy. I mean, because I feel that I have set aside an order. But where you show me, you are only saying the order. Where you have told the court that this is already I am deducting. This is the direction, and what is the court's finding on that? I mean, court has a order according to you.
Minutes.
But passing an order is not an error.
No, minutes.
Passing an order after considering the pleadings,
Minutes.
I mean, not taking into account the relevant considerations is an error. So don't read the order. You straight away come that where you have raised that 22/7/2024 is an order. Have I understood correctly?
Minutes.
That order you are complying since so many
Since
days.
days.
And then also there is a petition for attachment of salary.
Minutes.
There you have registered by filing WS, objection, whatever you call.
Minutes.
Broadly, it is WS. And saying that, yes, I am complying. And show the evidence also, of course. It can't be a matter of speech, it's a matter of paper.
Minutes. Page 27 of the order, minutes. They have recorded it.
Written statement, how can be formed? The judge is not a party. You are the protagonist.
Minutes. The written statement I have annexed here.
You
Objection-
said good there, sir. I've been asking you straight
sir.
away where you have said that
Page
first you go to
9.
petition where this attachment is not for, then the written statement. So that's you have prepared this brief yourself.
Minutes.
You should have read those things. You should have.
The
I mean,
Certified-
initially it will appear very, very complex,
minutes.
but legal propositions and these, once you become methodical and you are being trained, it becomes easier. And you should have a very clarity in approaching the problem. Very simple.
Minutes.
When the person comes to you, you have to ask these questions, or else why you will defend him? You are a lawyer.
Minutes.
He's not disclosing you the petition, not disclosing you the statement. Simply says that ମୁଁ ଆଜ୍ଞା ଦଉଥିଲି ପଇସା ତ ଆଜ୍ଞା ମୋ ଦରମା ବନ୍ଦ କରିଦେଲା ଆଜ୍ଞା. Appears to be very correct. I mean, a speech over a cup of coffee. But when you are approaching a legal issue,
Minutes.
why we are trained in counseling, client interviewing? That's the important part. Once you you have to present these things to the court. That's it. There is open and short case. There is an order, he has complied, then why there will be, attachment of salary?
Well, sir, given the written statement,
Start with the pleadings. What was the filing the plaint?
the pleadings, my lord, but he is not.
So that, what is the response?
The pleadings will have.
And also, what is the pronouncement of the Supreme Court on this? It is a 23 execution. It's still pending?
Still pending.
Still pending. How many years? 3 years,
Minutes.
roughly. 2 and some years. Supreme Court has issued guidelines and circulated, Rahul sir, that all execution applications should be disposed of within 1 year.
Minutes.
Look at the court also. Court is mandated by the highest court. This court also, of course. But executions are not here because we do not having original jurisdictions. So that is there. That is one end of it, because that is in the, when it been case specific, in general they have to dispose of. Execution 23 is kept pending for why? Why it is kept pending? Because it's not executed. And if so, let me tell you why I've been entering into a general discussion for your benefit, of course.
Minutes.
You have to tell the court that you have, as per the directed, execution is continuing. That much. One line defense.
Minutes.
Did you tell the court that?
I had
So
averred.
why is the petition first? What is the allegation?
No, sir.
Regarding execution?
I had averred that in my written statement. Minutes.
What is the evidence?
Well, it's
Then,
page 20.
then comes, you should prepare this way. Honorable the Chief Justice, former Chief Justice, as when he was Justice Deepak Mistra's judgment. So what is the scope of review in revision? What is the scope of revision?
Right.
Para 20 of Samima Farooq. The limit scope is very limited. So now, so let us start with what was the plaint first.
It's the
I'm just speaking aloud for so that to encourage you.
well, thanks.
You are satisfied as a lawyer that you will be there is so much to be as a student of law we are. So that way you approach. Yes, please. Straight away go to the pleading. What was the ground of approaching the court? Reason for or ground for approaching the court?
It's the execution pleading. Well, I had not annexed that one.
So have you got it? If you have got it, you can place it.
Plus, I have got the written statement which I had given to
You
the.
should not have. That has actually he has successfully, what you call, your client has successfully, clouded your thought. That is how you are finding it difficult to answer this thing. If there is an order of execution, again there is a petition filed for further execution petition, then what is the reason? That is the starting point. You examine it.
That's what I'm submitting to your lordship. Is that
You are not, so I'm asking you, sir,
Yes.
to place on, to read it. What is the plaint before the trial court? You said you have not annexed. I said if you are having, you can read it. No difficulty. Because it's a part of record of the trial court.
It's the order was passed on 22 of July 2024.
July 24.
24,
Yes.
and within a month the petition was filed again for the.
What is that? Where is that petition, sir?
Was that petition?
Sir, what you have done, sir, you have challenged challenged a revision without looking at the petition as it seems.
It's
Because you are saying you are not having it now.
I'll produce that petition.
Why should you produce it? You should read it before framing the challenging it.
It's
He has successfully narrated one side of the story. There you don't make you should not make compromise. You are officer. This profession is that special. He has to be truthful before you. Or else how you will defend? You do not know what was the ground for going to the court.
Since I've only relied on the payment which is recorded in the order, therefore I might have.
Then you have to make the judge a party. If he has imputed anything on his own, he bases his conclusion, derives his conclusion on the basis of the pleadings. Half of the main pleading you are not having. You start with the answer, written statement. Now please place the order. Then you will get the reasons also.
Page 26.
It's 26. Yes,
It's page-
9/12/25. Yes.
9/12/25. This order arises out of the petition filed on behalf of the petitioner on 29/8/2024 with the prayer for attachment of salary of the opposite party towards realization of area maintenance to the tune of rupees 4,13,000 for the period from June 2019 to September 2023 on the grounds stated therein. In support of the petitioner, it is
There
submitted.
you read slow so that you don't miss the fact.
No, that's- In support of the petitioner, it is submitted by learned counsel that this court in CRP number 423 of 2016, with a order dated 11/1/2019, has awarded maintenance at the rate of rupees 10,000 to the petitioner number 1 and at the rate of rupees 5,000 to petitioner number 2 per month from the date of application, that is 7/12/2016. But the opposite party with an ill intention is avoiding and delaying the payment, as a result of which the petitioners are facing hardships and it is difficult on their part to survive. It is further submitted that the opposite party, namely Ratikant Barik, is a
Exactly, Mr. 9 years, Mr.
pardon.
Exactly 9 years. 7/6/12/9/2025.
Again,
କେତେ ବର୍ଷ?
9 years.
So what the court will do? Executing court, what the court will do?
It's the area maintenance which the court itself was satisfied that 52 installments would be proper for him to. That's what the.
Sir, it is a luxury for you. It's a necessity for them. They have come with a begging bowl. That is our answer.
Let's see.
Rahul says why it says that it will be 1 year. You should have challenged that order 7/6/2006, 7/12/2016 order.
That order I had challenged. I failed in that order.
You have regularly violated, not paid. Then they come. Why the arrear mounted? Because you paid.
No, Manoj, I'll just.
You must understand what you are arguing.
Manoj.
You are arguing against yourself.
This RP, I had
Sir,
challenged.
this kind of attitude is a problem, sir.
Manoj, the
You
court.
deciding the judgment, good or bad. You means your client deciding whether to implement or not, whether to comply it within 10 years or not. That is how the Supreme Court has passed guidelines.
This the regular maintenance I have been paying. The area maintenance.
Sir, then how it is arrear? I've been asking you. There you are struggling.
Manoj, the area.
And the arrear can be for 9 years.
No, area is for Manoj, 2019 to 2023.
Date of application.
Manoj, that's
You
what.
are missing the dates also. I can't be better prepared in facts than you. I'm a judge. I'm having so many briefs. Date of application is 7/12/2016.
Manoj.
And this is a 9/12/25 order. आपको installment केबे ହେଲା?
Installment ହେଲା 22/7/2024.
So after almost 22/7 to
22/7.
1 year 2 months, 14 months. What has happened? That I'm asking you.
20.
For the 14 months, what has happened?
20.
Why you are not bringing that on record? Why you did not go to the court? Sir, I'm paying. Worship, I'm paying, or Your Honor, I'm paying. That's it. It is as one line.
That's 22/7, the 22/7/2024 order was passed. I complied with that order.
Sir, how you have complied? Where you have shown?
That is recorded here, Manoj.
Where?
Page 27.
No, you read the entire order there.
Manoj, I'm reading.
26.
I'm reading the entire.
26 for a third para problem. This case is filed
This case is filed for realization of arrear maintenance amount. It is the specific prayer by the petitioners that the direction may kindly be imparted to the employer of the opposite party to deduct the arrear maintenance amount from the salary of the opposite party.
Oh.
The opposite party has appeared and filed his objection in which he stated that he is paying the arrear maintenance dues regularly. This is a petition for execution under section 128 of CRPC by the petitioners for execution of order dated 11/1/2019 passed in CRP 423 of 2006.
11/1/19 order টা কোটি আছে দেখিলে
11/2019.
ঠিক আছে ডিস্টার্ব হবেন না এবার enough distraction for you আবার পড়ুন
Not that 11. Passed in CRP, wherein the court had directed opposite party to pay rupees 10,000 to petition number 1 and rupees 5,000 per month to petition number 2. As per the submission of the petitioners, the arrear maintenance amount due from opposite party is rupees 4,13,000 from the period June 2019 to September 2023.
Yeah. Then kindly mark, he has taken note. Out of total
Arrear maintenance amount of rupees 7,68,000. The opposite party has already paid rupees 3,55,000 with various DDs.
Correct.
The arrear is calculated at rupees 4,13,000
Yes.
from the period June 2019 to September 2023 payable by the opposite party. Considering the facts and circumstances, it deems proper to direct the DDO cum 151 BN CRPF, Kaliveru Satyanaranpuram Cherla Mandal, is the address of the opposite party for attachment of the salary of opposite party for realization of arrear interim maintenance amount to the tune of rupees 4,13,000 for the period from June 2019 to September 2023. It is decided by the court that a sum of rupees 20,000 per month will be deducted from the salary of opposite party and the amount will be credited to the account of petition number 1, Srimati Lakshmi Priya Barik, vide her account number so and so, State Bank of India. The deduction of rupees 20,000 will start from the month of January 2026, payable in the month of February 2026, till realization of entire arrear maintenance amount of rupees 4,13,000. Once the arrear amount of rupees 4,13,000 is realized, the deduction amount will be reduced to rupees 15,000 in every month towards regular monthly maintenance amount. At the cost of repetition, it is held that rupees 20,000 will be deducted from the salary of opposite party towards arrear maintenance amount from the month of January 2026 till month of September 2027. Therefore, deduction of 20,000 will continue for 20 months from January 26 till month of August 27, which is calculated at rupees 4 lakh, and the remaining amount of rupees 13,000 will be deducted in the month of September 2027. Once the area maintenance amount of rupees 4,13,000 is deducted,
So according to you, how much is deducted every month from your salary?
well, sir, I have been paying 15,000.
Right now, after this,
After this, they have not deducted yet.
how much?
They'll deduct 20,000 per month.
20,000.
20,000.
So what is your total salary?
My total salary is 50,000. I have got the passbook. I could just get.
Not passbook. You have to get the salary certificate from the CRPF, or you will get it from Bhubaneswar. What you are working as?
I'm commandant.
Commandant. Commandant CRPF salary. Take home salary kete dekh.
I'm assistant sub inspector.
Yes, sir.
ASI.
Okay.
ASI. Sorry.
Commandant. But you are not sure how much is you are, because though that you are right that what is there, salary is attached. But I think it is to the, I mean, apart from deduction, there is no direction that rest will be retained by the, because there is no direction also that you will be unable to draw any salary. And unless the attachment is there, how you will direct 20,000 per month?
That's
What is the consequence of this? That I was trying to understand from you.
What's the
So
consequence?
then you come prepared. What is the you get all the pleadings and also prepare, ask him to that how much he has paid and when. So earlier just look at that first order. Just look at it. Where you started actually the direction.
Page 23.
Yes,
That was with the consent of both the parties.
correct, sir. What is the deduction?
The deduction was 15,000 for each installment.
So now it is only 5,000 more.
The problem is, they are resorting to an attachment.
No, attachment means unless you pay it, then if it is not attached, you will not pay it.
But I have been paying it,
So you file it for the court that I am paying. So the evidence 15,000 initially. What you have argued that as if everything has been deducted. There is no order. 15,000 has been increased to 20,000, and court is very lenient towards you. Your total amount due is as per the calculation on that date. In fact, you have not disputed that.
They could have revised that installment itself without resorting to attachment of my salary.
So what is the direction for deducting the entire salary towards the salary? Because it's an installment. So for that, you should have sought for a clarification or challenge in appeal. Because how can I now say that 20,000 should not be deducted? You are happy with 15,000?
No.
Unhappy with 20,000?
I'm not on the quantum. If your lordship,
Quantum, you are happy.
If your lordship should say that 20,000 I'll give as per the installment.
Sir, I'm not assisting to the trial court.
I'm
You have to tell the trial court, sir, I'll be paying 20,000 directly. Then why the attachment? And in fact, there is no, he shall not, usually in case of a attachment, there is a direction that he will not draw his salary. There is nothing. In fact, there is no direction regarding the rest of the amount also.
It's because this
It
was
is somewhat, you are right that what is there. I told you. But as you complete reading, so now the total area is 4,13,000.
4,13,000.
You are not disputing that. Because it is a
7 lakh
calculation. So 4,13,000, they are allowing you total maintenance amount is?
Total
Maintenance per month is now?
maintenance per month is 15,000.
So 5,000 for towards a year. I'm not following what. In fact, rather I took it very seriously, so I discussed everything. 15,000 current, 5,000 area. And the total area is 4,13,000.
4,13,000.
So how much you will pay towards area, according to you?
I'll pay. I am saying I'll pay as per the order which was passed in 2022.
So you pay, you move the court. Even I'm not asking you to withdraw it. That's not my. I mean, my endeavor is to understand and to arrive at a conclusion. And you being a young counsel, so I've been discussing with you. So if you are paying 15,000 and 5,000 is the easiest of installments. 4,13,000 you have not paid.
4,13,000.
So if you divide it, so every month, so per year is 60,000. 4 lakh is almost 8 years, 7 years.
The installment is already fixed. It would end.
Are कौन फिर installment को पढ़ो चलो?
52 installments, sir.
Whatever, sir. I said 4 years, you are saying 52. 4 years is 48 months.
48 months.
So exactly, so I'm saying that. So can you not do this mental arithmetic once look at here and there?
No.
So what is the difficulty for you?
No, sir.
And if there is a attachment of your, there is no direction actually that you cannot withdraw any money.
Well, see, there is some consequences, because there's
I cannot presume that. I cannot presume that when
because
I
it concerns my
can
service.
put lines into the order of the court. That the
Because
petitioner, you first, you approach the court.
since it concerns my service also, because
What service?
there's an attachment to that effect to my salary.
Yes,
So, well, it's,
because you
I
have not
don't know
paid, for 52 months you have not paid it.
no, I've been paying
You
as per the
understand what I'm saying?
my
The future 52 months is quite the past 52 months. So what service you are saying? I'm unable to that. It nothing to do with your service. You continue as a ASI.
since I've been paying with that installment, let them not resort because it is as good as a punitive measure.
It's not a punitive measure.
Because they have already devised a mode of recovery.
How can a decree be a punitive measure?
Which is already a mode of recovery was.
Should I observe and reject that?
That will lordship may not.
Then why should you say that? Court passing a decree and you are not complying with the decree, it's a punitive measure.
No, I was complying with the decree which just passed.
So you have so many things to say regarding the salary and the service. But what do you say about compliance of the decree of a court?
Well,
Then why the court is there? Or the section is there? Why there is execution? Sorry. That needs to be rejected. 15,000 normal. 5,000 towards 52 installments a year. That's it. It is easiest of installment.
15,000. Well, 15,000 was also fixed.
Anyhow, I am not granting any stay because I cannot. I cannot grant stay.
So I've been.
I do not have reasons as directed by Supreme Court. Supreme Court has,
Listen,
in case of interim matter, I just now read by Mr. Singh. High Court should not have.
so I'll continue to pay as I'm paying. Well,
You continue and draw this to the attention of the court because the court has used the word loosely. But attachment, I think it has a different connotation. The account is seized, frozen, attached. It's different thing. Attachment because that quantum of money, if it is not to the credit of the execution, then there is a possibility the rest of the amount will be, it's kind of creating a lien.
The
other matter just now I discussed, we are creating a lien, even if we are allowing the money to be deposited, the decretal due. Money decree is secured in High Court. What we are doing? That the amount shall be kept in SD to the credit of the appeal. Even in certain cases, the wife is not allowed to withdraw it. Then you will be taking away the entire money, and you have not shown any consequence out of that. Because the order is very clear. Salary is attached. Attachment is towards the decretal dues. 15,000 current, 5,000 area. In fact, there is no change also. Initially, I thought actually when you argued with so much of you have prepared the matter. It's not that I am not finding any fault. But I was under the impression that the court has taken away the entire money.
That was not.
No, that's not there.
That was not done. I was just submitting to the lordship that
I cannot put lines into the order of a court. I cannot.
Then I may be permitted to move application before the court below.
Definitely. That is how, sir, about 5-10 minutes back I told you. I am not asking you to withdraw this, but since you are not ready, or you do not have you are ready, but your client is not ready. He has not shown you the plane.
He has also
and the court is very lenient. Why the court will grant 52 months for satisfying a decree?
That order is also still in force. That has not been
in thousands. In today's world, how much the mother and how many children?
It's one child.
So mother and child 20,000 the court has granted is very lenient for 52 weeks. 52 months, sorry, 52 months.
That was, I'm not
Just
totally.
imagine,
quantum-
Mr. Das,
No, no.
it could have been 25,000 at least.
No,
Because can non-payment of a decretal amount is be given imprimatur like this? You see the other side. And I do not have any reasons to interfere.
because I'm just submitting a lot.
So
That
you-
since they had devised a method
It is
to
your
realize the.
you take the call whether you will move the court and beforehand. I mean, you will, but whether you withdraw this petition, that is your. I'm not asking you that you withdraw it today. But there is no order. If you I have read with you, and before you read, I had.
My lords may keep it on Friday. My lords.
Before you read, also I have read it. I have read and reread.
My lords.
Because I understood, I thought that you are saying the entire money is to be parked. There's no such order.
No, no, I was not on the quantum. I was just saying that since that is a kind of a coercive step,
I think it's a loose
Coercive.
used word.
and that was also initiated at the
The
very.
problem is unless it is like this, how to restrict you not from withdrawing the money?
Listen, if I fail to.
Somebody, I realize, yes, you have answered it now. Good.
If I fail to
The only way to prevent you from taking away the entire money is attaching it. So you move the court, you will tell that I have this legal necessity. So you have a medical emergency. God forbid, nothing would happen. Some payment of dues, income tax. You will take the money. Is not it? That is how the attachment. The order is correct. And they are, and the court is very lenient, considering that you are a ASI, 60,000-70,000 salary total emoluments, 5,000 per month, and 5,000 for 52 months. They have a genuine cause, Mr. Das. So you take your time. I'm adjourning.
My lords may keep it on Friday because
Yes,
if
yes,
I have to
yes,
move an
yes,
application, then I'll.
Yes, Mr. Kondekile, appearance. The petitioner husband is before this court. Challenging the order dated 9/12/2025. And spending more time with you is not to dissuade you.
No, I
So
understand.
that the participative interaction is open-ended. I am not forming any opinion. Regarding the case, you must realize that. It's a broader perspective. Anything? See, କାମ করতে ସାଥି ଦେଇକି ଆସନ୍ତୁ ନହେଲେ କଣ ସରିଗଲାଣି ଏଇଟା ଜଷ୍ଟ ଆରମ୍ଭ ହେଲା passed by the you take your seat Mr. Das I'll take some time by the learned judge family court Balasur execution bracket execution C.R.P.300 of 2023. Referring to the ordering portion at internal page mark kono nahi setre paragraph mark to nahi joti lecture attachment page mark kon jana paduni na page mark raheni lower court re
Page 28 na
28 ta apon ame seta 28 is our running page order ro paragraph to nahi but
paragraph nahi
page mark bhi
nahi
na upar uthi koti jaisi
nahi sir nahi खाली गोटे ताकर ऑर्डर नंबर 40 एमती लिखिचंती
ordering portion at page 26 of the petition annexed to the writ petition marked as annexure 4 it is submitted that direction for attachment of salary has been passed. कोई जगह छड़ा पाइले अपन आउटर रिपोर्ट देखिले पेज 27
27 to 28.
नहीं 27 ने को पैराग्राफ तो नंबर ही नहीं को सब पारा कोटा
Subpara 4, 5. 4, sir. 4. 4. Considering the facts and circumstances.
अच्छा ठीक है तो कौन The relevant portion of the order number 40 dated 9/12/2025 is the produced hearing on page 27 में पाइए. Considering the facts and circumstances to make it September to 2023. Apparently, there is no direction for freezing of the salary account, but for realization of entire area maintenance amount of rupees 4,13,3,000 due from date of application कितनी 11/19
7/12/2016.
7/12/2016 The Lorded Court has directed 5,000 per month to be deducted for 52 months. An amount of rupees 15,000 is to be paid as the regular maintenance per month. Prima facie reading of the order passed by the Lorded Trial Court does not disclose any impediment for the petitioner to have his share of salary after deduction of rupees 15,000 towards foreign maintenance, 5,000 towards area. The Lorded Counsel for the petitioner seeks and has adjournment. List in the
Friday.
No, but you have to talk to him. He must understand what he's doing.
I'll talk to him. I'll also get that petitions before Lordship.
Not only that, because there's no direction for, freezing your account. Unless they create a charge on that towards the future payment.
No.
How they ensure payment of 4,13,000, which you have, of course, answered.
No.
That's the only way. Unless this court directs 4,13,000 in future has to be deducted. So for that, it has to be attached.
Because
But there is no order for that reason that the petitioner shall not draw any money from the salary. Unless it is attached, they cannot ensure. You will take away the money.
let it be on Friday. I'll take.
No, you can take time, further time. For the timing, because I will not interfere in this matter.
Because
There is sufficient warning from the Supreme Court.
in the event also Lordships, because I'll also seek a Lordship's indulgence.
Because if you are seeking clarification from that court, you will require more time. Because you are not telling what is the difficulty. Only saying that my salary has been attached. Salary has to be attached. Otherwise, 4,13,000. Current 15,000 is no difficulty because every year, every month it is recurring and you are giving it. But there is a area non-compliant decree.
So the area is already, they have devised that mechanism for an installment. So I have been complying that. So there is had that.
Sir, I have told you, you have said nothing for area. 15,000 is current.
No.
Or 13,000 is current.
15,000 is the current maintenance is 15,000.
So
then
then-
area is also 15,000.
Eh?
Area is also
So
15,000.
30,000 is not deducted. 20,000 is deducted.
20,000 deducted. Matlab, I have been
5,000 towards area.
paying 30,000. I have been paying 30,000 all throughout.
Then it has been reduced for in your favor.
But they are attaching my salary. Matlab, I am paying as per the order which
Sir, what is the difficulty? You have to show to the court that after attachment of your salary, you have not been able to draw any money. List on, as prayed for, list on. Today is 4. List in the week commencing 9th February 2020.
Item 5.
My lord, may I pardon, my lord. Item 5, I have filed a memo, my lord, for withdrawal of the writ application with liberty to file a fresh petition.
Mr. Devendra Mahanta for the petitioner. The Honorable Counsel for the petitioner presenting VC addresses applicants. Memo of date has been filed by the petitioner. Filed on behalf of the petitioner, which states thus. Accordingly, the petition is disposed of, granting liberty as paid for.
Obliged.
Item 6.
Item 6, you'll also be praying for an adjournment, you'll also
Arjun call.
deeply obliged.
Now, data koi diyo. Extra adjournment koi.
16. Full comments.
Deeply obliged.
7.
On behalf of Devasys Tripathi, my lord, there is no instruction from the side of the petitioner, my lord.
He has to file that memo. It can't be
My lord, file memo. In course of day, I'll file memo.
or will dispose it of.
I'll file memo.
He's there to sign the memo.
No, my lord, I have not cited.
He's not in the campus. The party is there in the campus. You get the memo. Pass over. I'm passing it over.
My lord.
Pass over. Next.
Item 8.
Item 8.
Your Lord, I'm petitioner person.
Bring in person, sir.
Item 8, my lord, sir, I have not received the instruction regarding that amendment petitions by my friend has filed. I pray some time.
Your Lordship, I have already filed the amendment prayer as per the direction of this honorable court.
So which order?
This is a case of, Your Lordship, educational service matter.
No, sir. Amendment, you are saying court's order is there. So the order date.
Yeah, the
Item 8.
previous board,
eight.
Justice Nursing,
Siddhartha Kumar Sahoo.
yeah.
The state. But this matter, it was before the Supreme Court in contempt.
Yeah, Lordship, Honorable Supreme Court has made direction in 2 parts.
No, I have a purpose in asking.
Uh-huh.
Once I appeared before Supreme Court, along with the present Solicitor General.
Yeah. Yeah.
So I'm not sure whether I should take it up. May not be this matter.
No, may not be this matter. Yeah, I was there in the Honorable Supreme Court. I was there. This is not that matter, Your Lordship.
No. The problem is different. Like, since I was appearing for state, I can't say that this matter, that matter. That's another problem. But yes, Mr. Lenka, what to do? No, I never appeared in this matter as a opposite party counsel. Or I appeared also. Record check kale? Just apart file aschi ki?
File. Verify from the order sheet. Not sure. You will be left there.
Between 16 to 21, I had not, I don't think, but one matter, once I had appeared,
Your Lordship allows me to place my 4 to 5 documents I will rely.
no, sir.
What injustice has been done?
I'm not there. I'm asking something else, whether I can take this up or I'm concerned in the matter. So that's the difficulty. Here the prayer is for what?
The prayer is that the notification after the Honorable Supreme Court direction they have made, the opposite party, the notification lacks this thing, and 10 years they have been deducted from my career advancement. That I want to place the grounds.
The last order by the Supreme Court. You have?
Yeah, in flag X, the Lordship. The order of the Honorable Supreme Court. In the last paragraph, the Lordship may read, the Lordship. Flag X.
There is no flag X. There is no flag X in the custom.
Mr. Linka, use this.
In any case, my lord, he has filed an application for amendment. So I seek time to file objection.
This 2007. It's 2017, third, 20th March 2017, 2017.
Yes.
I think this I had appeared.
Next my release matter.
So,
For some.
so I was looking at whether it is mentioned. Look at flag X, dekh le.
Flag X.
तब
And Justice Kirian. Kirian Joseph and
ছয় চারি পরে যেটা আছে দেখুন তো ছয় চারি পরে appearance ଅଛି ନା ମୋ ନାଁ ନାହିଁ but I was there. Tushar Mehta, Additional Solicitor General.
yes.
The matter may be listed before a bench where MS Sahoo J is not a member.
Your Lordship,
The petitioner has the liberty to move the registry to do the legal. Yes, Mr. Sam.
Tushar Mehta, Assistant Solicitor General, SP Mishra.
So purposefully, I did not look at this and told you from my memory. Now, when I check, the appearance is, my name is not there.
No.
Yes.
Because what happens in Supreme Court, on the day you write in a slip and hand it over. This I was telling you, in fact, so that is how then I asked before looking at it that what was the last order. Then you said flag X. Then I checked it. Purposefully, I tried to go by the, yes. So it will be coming before any other bench. No difficulty.
Is there any harm, Your Lordship? We can.
No, some, you see, at times, you are not aware. Maybe you may not be aware, but it has already have noticed it. though my deliberations are in detail in court, it is not that I'm reading the brief along with the learned counsel. Not that I'm preparing too much on a particular brief. Yes.
Item 9.
This serious injustice has been done to me, Your Lordship.
The
By
difficulty is
10
that,
years.
Otherwise, also in so many matters I have appeared. That is, but for that I cannot. But this particular matter I remember because we. Yes. So to be listed there before. It was not in my determination also. My determination may change also. I mean, it's a matter of chance. Which court is hearing on which date. So, I mean, it's a matter of chance. Yes.
With the next date to some.
Next date actually you have to move because I cannot direct a particular court. They have to obtain instruction on the administrative side from the Honorable the Chief Justice.
Sir, as early as possible, it is because it's too late already. I'm retired already 5 years over.
That I cannot do. I must understand my limitations. Directing the registry, because that is not the jurisdiction. I mean, that's the prerogative of the Chief Justice. Please appreciate that. And that they will go in administrative side. But I have already said that you have the liberty to move the registry. You can move the registry, deputy registrar. Yes, next.
May please, Your Lordship. Item 9, my lords, I am for the petitioner. But I would seek for a short adjournment a day, just a week after, my lords. I need to reconstitute the file. Just an apology from my side.
May I please, Your Lordship? Your Lordship.
Yes, Ms. Sarkar.
Your Lordship, I'm appearing for the Y opposite party, Your Lordship.
They are not paying money.
Your Lordship, this matter has been stayed since 2019. I have filed an IA, Your Lordship. I'm submitting the copy. The short date may be fixed, Your Lordship.
Mr. B. Panigrahi for the petitioner.
I'm on behalf of Mr. B.
He was there. Mr. Panigrahi was there. You are Mr.
S. Sharma.
Mr. S. Sharma, Subham Sharma. Mr. B. Panigrahi and Mr. Subham Sharma. For the petitioner, Ms. J. Sarkar for the opposite party.
Parties, Your Lordship.
Parties.
Yes, sir.
What he does, he's an employee.
Let's an admitted case that he's an employee. Admitted case that my salary is 20,000 some odds.
So what was the awarded amount?
Awarded it is against the enhancement of the maintenance, my lords. Maintenance initially it was awarded for wife was 5,000 and for daughter it was 2,000.
Your Lordship.
Sir, what is tell the amount and straight away come to the point because we are any sort of time.
Filed the salary
because of the longer deliberation.
My lords.
What was the amount directed and how much is it?
7,000 and 5,000 he is paying.
From
5,000 paid.
7,000 was awarded, Your Lordship.
He has been paying.
He was paying 5,000 after taking the stay, Your Lordship. And since 2025, he is not paying, Your Lordship.
So the entire order was stayed or the enhancement order was stayed?
Only the enhancement order.
Then how can you?
My lords.
Contempt.
My lords, I will just get why I seek a time below because I just...
For that you need not seek any time or the brief also.
My lords.
I hope you understand.
My lords. Just a week time I will...
ask him to... Or else you will face the wrath of the court.
My lords. Plus I will be there, Your Lordship, to assist whatever...
Hope you understand
my
what
lords.
I'm saying.
My lords.
So what is the proposition?
My lords, just...
Though the High Court has not stayed the payment, you have stopped paying.
Stop paying. As far as my learned friend is concerned, I have to seek instruction on this part. My lords. I'll be before Your Lordships.
Comply.
My lords.
So you can't play tricks with all the courts.
My lords.
All the time.
I'll be there before Your
Some
Lordships.
of the courts will be at a higher rate. They will catch off. Catch up with you. This running around with courts is not it's not always a profitable thing. IA number 3 of 2026. Hard Lorded Counsel for the opposite party. Petitioner. The IA has been filed seeking for appropriate orders as well as vacation of interim order dated 18/6/2019, passed in RPFM number 48 of 2019. Let him appear in person.
Yes, your lordship.
How he can play tricks with the High Court order?
ଯଦି ଗୋଟିଏ opportunity ଦେବେ ମୁଁ
Aଜ୍ଞା, opportunity to
responsibility to
when did he ask for the opportunity and he has not given the opportunity?
only because I
Don't make pretentious submissions.
ନାଇଁ ମୋ ପାଖରେ instruction ନାହିଁ ବୋଲି ମୁଁ ଟିକେ
You did not, sir. You did not bother. He is not bothered. Why you are bothered?
ଗୋଟେ opportunity
Since when he is not paying?
Your lordship, since 2025, your lordship, in the present IA, I have annexed his salary slip, your lordship. He's a government professor, your lordship, paying, he is getting 82,000 per month, your lordship, and not even paying 5,000.
Give his address. Employer details.
Your lordship, that is in Annexer 1, your lordship.
Okay. By the say, dictation कौन है? Order dated 18/6/2019. RPFM 48 of 2019 and IN number 103 of 2019. By 18/6/2019, the following was directed by the coordinate bench. It is a matter of concern that the said order of this court by the coordinate bench has been defied with impunity to the detriment of the opposite parties and petitioners in the present time. The order is 14.3 and 18.6. तापर ଗୋଟେ line add कर दियो तो the order dated 18/6/2019 as would subsequently modified by order dated 22/7/2019. The order data quote कर देंगे. Ms. Sarkar, actually you are also under wrong impression.
Your lordship.
Why you want to vacation of the order which is in your favor?
Your lordship, I am.
Court has directed to pay.
Yes, yes.
You want vacation? They should seek further modification. You are seeking modification.
Your lordship, the reason is I have filed for an enhancement in court below, your lordship, and they are not taking any step because of
You
the
are
matter
not-
has been.
you are not listening. When you are saying that he is not paying because of the stay,
Yes, sir.
that is incorrect. This court has directed to pay 5,000.
Yes, your lordship.
That he is not paying.
Yes, your lordship.
So that order is in your favor. A order by the coordinate bench directing him to pay you. How can it be in your against? So that I'm asking you. Maybe you have filed the petition in a hurry. I don't know what is the reason.
Lordship.
This is the second time. Yesterday, a lady has paid for setting aside the order awarding maintenance per month. Though she seeks enhancement. You may seek enhancement, that is a modification. But why you want vacation of that order or modification?
I might be. My
Yes, you have
apologies,
to
your
check-
lordship.
You have to check your facts. In fact, you never cited these two orders.
Yes, your lordship.
I have while discussing with Mr. Sharma, I have found it out.
Yes, your lordship.
Whether actually there was a stay. There is no stay.
Your lordship.
The Lorded Counsel for the petitioner seeks accommodation to reconstitute his brief, as the same has been misplaced. So, the petitioner shall the drawing and dispersing authority that is Principal Ramachandra Madara Science College, Khalikot. Has issued salary certificate pursuant to the RTA application of the amount of rupees 81,049. The gross amount being 93,620. Towards payment of the arrears pending as directed by the coordinate bench by order dated 22.07.2019. 22/7/19 ରୁ 25 ହେଇଗଲା 6 ବର୍ଷ।
25 ରେ ସେମାନେ କହୁଛନ୍ତି ଆମେ ଡିଫଲ୍ଟ କରୁଛୁ। ଆଇ ହାଭ୍ ନୋ ଇନଷ୍ଟ୍ରୁ ସେମାନଙ୍କ ଅନୁସାରେ ଆମେ 25 ରୁ ଡିଫଲ୍ଟ କରୁଛୁ।
ସେଇଟା ସେ ବୁଝେଇଦେବେ ଆପଣ ଏବେ ବୁଝେଇଦେବେ।
Milos, as an officer, as an officer of right, the responsibility that this order is to be complied, my lords.
Yes, sir.
Just gote accommodation is what I
They will say that you do not have the responsibility.
No.
So don't state obvious. These pretension submissions are always
my lords.
somehow that tickles me.
Milos, it is our duty to make them understand that this order is there.
Hold the magistrate.
My lords.
So don't make pretension submission.
It is my duty that they comply with this order of your lordship.
Duty to defy order.
My lords.
Please don't make pretension submissions. That's spacious. Empty, all empty, no data.
Nothing. Properly, your lordship
So,
will call for its appearance.
From 2019, arrear amount 2019 ହେଲେ 22/7/19 ରୁ 25 ହଉଛି. That is for the for 72 plus 5, 77 months. The amount would be, the amount if not paid for 77 months comes to 77 into 5. ହେଲା calculator ପକେଇ କରିଦେବେ. ଖରା. The petitioner, the ଆପଣ ତାଙ୍କର ଆକାଉଣ୍ଟ ଆଣିକି ଦିଅନ୍ତୁ ଫୋନରେ ବୁଝି.
Yes, your lordship.
And the rest part, the amount of rupees, the so and so principal जो लिखलेନି ଅଛି ସେଟା ଆପଣ ସେଟା IR annexer ରେ page ଅଛି. ହଁ, yes, correct. Shall credit the amount of rupees
Your lordship.
20,000 towards arrear and 5,000 towards the current maintenance as directed earlier. Every month. The petitioner has liberty to file before this court the affidavit indicating the details of the payments already made pursuant to the orders of this court dated 22/7/2019. According to the order of deduction of 20,000 towards arrear and 5,000 current maintenance. ବର୍ତ୍ତମାନ 5/2 ଦୁଇଟା କଣ ଟୋଟାଲ 7,000
7,000
ତାହେଲେ 7,000 5 ତ 7 କରିଦେବେ.
ଡଟର ପାଇଁ 2, ୱାଇଫ ପାଇଁ 5,000.
ଆପଣଙ୍କର ଥିଲା 7,000 ବଢିଲା 10,000 ହେଇଥିଲା.
ନାଇଁ ଥିଲା 5,000 ବଢିକି 6,000 କଲେ. ସେଇଟା ଝିଅର ଥିଲା 2,000 ବଢିକି 4,000 କଲେ. Now by the interim order dated 18/6/2019 we have been deducting
2,000 per annum କଣ?
No, it is
Your
funds.
lordship, that is for the school expenses. That's what extra awarded for 2,000 per year. Your lordship,
Sir, educational expenses.
one thing I need, your lordship, I want to bring into your notice, your lordship. The
Madam,
petition-
you are actually chopping up the branch where you are sitting.
Actually, here the issue is.
Happening in matrimonial matters.
Yes, your lordship.
You have an order from the High Court, you want recall of that order.
Your
So
lordship.
let us wait. You also be patient.
Your lordship, they,
Now he will get instruction. He will get the file also.
they need to correct something, your lordship. They have filed this RPFM but the certified copy they have produced, that is not with the present case, your lordship. That is not related to the present case.
Could be. Let us not deviate from the topic, the course we have adopted.
Yes, sir.
Accordingly. Shall be subject to further orders of this court. The opposite party shall also shall obtain instruction. Learned counsel of the opposite party shall also obtain instruction regarding the amount receipt from the date of the initial order. That is from the date of initial application. It has to be application in the year 2015. Mr. Sharma, it has to be from the date of application. It cannot be. So let us see.
Next date, I will apprise your lordship of all the facts.
Once you just the Lord Council are requested to exchange the affidavits that would be filed. You can file your affidavit.
Yes, sir.
Yes. Rest of the matters after recess, any adjournments?
Your Lordship, a specific date may be fixed, Your Lordship.
Mr. Sharma केबे?
Immediately, Your Lordship.
23 मैं 3 ही
So in month of February, Your Lordship.
23 कर दूं ठीक है
Can it be first week of March or not last Saturday, February last 27, 26, 27?
23 पर करा ହେଲା ଆପଣଙ୍କ କଥା ରହିବ
February 26.
ଆପଣଙ୍କ କଥା ହିଁ ରହିଯାଇଛି
Blessed, Your Lordship. No, no, but
ଯୋଉଟା ଯେ କହିବେ ପଳେଇଲେ
Recording in
ଦେଲେ
progress.
ସାର୍ ବି ପଳେଇଲେ ମେମୋ ବି ପଳେଇଲା ଦସ୍ତଖତ ବି ଯାଇଥିଲେ ସେ ତ୍ରିପାଠୀ ଆସିନଥିଲେ କହିଲେ ମୁଁ ହଉ ଆଉ ଥରେ ଡାକିବେ ନହେଲେ କାଲି କାଣିବେ ଆଉ କଣ ଆଜ୍ଞା 10 କଲ୍ ହେଇଯାଇଛି 10 ସରିଛି ଦେଖନ୍ତୁ ପାସ୍ ଓଭର କରିଦିଅନ୍ତୁ ଦେଖିବା Ratching is also not there. Call କରନ୍ତୁ call କରନ୍ତୁ
Item 11.
ତ ହେମନ୍ତ କୁମାର ରାଜସିଂ ସେ RAT ଲେଖୁଛନ୍ତି ରହିତୁ ଲେଖୁନାହାନ୍ତି RAT ମାନେ mouse and lion rat and singer yes Mr. Hemant Kumar Ratsing for the petitioner opposite party blank the petitioner husband is before this court challenging the order dated 3/11/2021 passed by the Learned Judge Family Court Jagatsinghpur in CP number 195 of 2020 stop said petition was filed under section 24 of the Hindu Marriage Act by the wife in the marriage arising out of the CP number 195 of 2020 filed by the husband under section 13 of the Hindu Marriage Act where she was the opposite party. By order dated 3/11/21 the petition filed under section 24 of the Hindu Marriage Act was allowed, granting 15,000 towards monthly maintenance and rupees 30,000 towards litigation expenses. Stop. When the matter is taken up today, the Learned Counsel for the petitioner files memo of date stating thus. Memo of date, stop. A comma which states thus. Then colon, Peter will do. The memo is taken on record. The petition is disposed of. Memo is taken on record, scan copy be updated. So that's all upon default should I record. Yes, so well done. As prayed for by the Learned Counsel for Mr. Sarada Prasanna Sodangi, 12 SP Sodangi for the petitioner. Opposite party black. As prayed for by the Learned Counsel for the petitioner. List in the week commencing. No, 3. 9/2/2026. Okay.
13.
Tripathi. Mr. Ajit Kumar Tripathi for the petitioner.
Defect has already been removed today.
Yes, please.
Receipt is also there.
CORA is service of copy.
No, or was the authentication fee of.
Which I have not paid.
Yes, not paid.
It is submitted by the learned counsel for the Mr. Ajit Kumar Tripathi for the petitioner. He is very happy to take your, when I dictate, take up your matters. My secretary is very happy. And apart from my school, he was senior. His name is also Ajit Kumar. So, Ajit Kumar, counsel for the petition, the defect 4A as pointed by the SR regarding authentication fee to be paid has already been removed. Okay, positive picture. Has been paid. The payment of court fees is substantiated by the receipt produced in the court. The receipt shall be filed in the registry. I trust. Obviously, I have to. Produced in the court, scanned copy shall be taken on record, shall be filed in the registry, shall be taken on record, shall be filed in the registry and taken on record. Scan copy be updated. Yes, you can submit on merits. The learned counsel for the petitioner is permitted to submit. Today, you want to address on merits?
Admission or the case is like this, my lord.
First, you come to the point where what is under challenge.
Yes, under challenge.
You have to look into the orders for the learned court. This is a revision.
Yes. Because initially the criminal proceeding by CRP number 574/91 under section 125 CRPC was filed and it was compromised. The compromise petition as well as the order of the court dated 6/3/95 is at Annex 1.
Is as old as 2011.
291.
606/2011.
ତା ପୂର୍ବରୁ
ତାପରେ ହେଲା ତାପରେ 470/2014.
14 ସେଟା 606ଟା ଏକ୍ସପାର୍ଟି ଅର୍ଡର ହେଇଥିଲା।
15 ବର୍ଷ ହେଲା ଚାଲିଛି ନା ବେଶୀ ହେଇଗଲା 2017 ବର୍ଷ।
ଆକ୍ଚୁଆଲି ସେ କମ୍ପ୍ରମାଇଜ ହେଇକି ଟଙ୍କା ନଉଥିଲେ। କମ୍ପ୍ରମାଇଜ ହେଇଥିଲା 91 ମସିହାର କ୍ରିମିନାଲ ପ୍ରୋସିଡିଂ ରେ। 95 ମସିହାରେ କମ୍ପ୍ରମାଇଜ ସେ ମାତ୍ର 300 ଟଙ୍କା ନେଲେ।
35 years 91 means 35 years।
ଆଉ ସେଥିରେ ଲେଖା ହେଇଥିଲା କମ୍ପ୍ରମାଇଜରେ ଯେ ଆଉ ଭବିଷ୍ୟତରେ କରିବେ ନାହିଁ, କ୍ଲେମ କିଛି କରିବେ ନାହିଁ, କାହିଁକିନା ସେ ଗୋଟେ ରିଚ୍ ଫ୍ୟାମିଲିର ଇଏ କେବଳ ଇନ୍ ଟୋକନ ଅଫ ଇଏ
these kind of compromises are dealt in contract law. There is a section, inconscionable contract. So
thereafter after
both of you and somebody appear that you waive your fundamental right.
Yes,
it cannot be. So maintenance is a dynamic thing.
Yes.
In 1991,
yes,
we felt that the costs have become so high.
Yes,
but life was much easier than today.
After 17 years,
so compromising maintenance amount in the court should not allow such compromise actually. Anyway, then what happened? After 35 years,
after 17 years, the
petition was filed.
The petition for enhancement of the maintenance was filed.
That was
it was decided ex parte. Challenging that ex parte order.
Even ex parte, sir. What was the amount awarded after 300? How much amount was awarded?
4,000.
4,000 in 2014.
14.
Yes.
Challenging that ex parte order, CRP number 470/14 was filed under section 126(2) CRPC. That was rejected, and against that this revision has been filed.
So when 4,000 was allowed, the salary was 20,000. What was he?
Now he's a retired person. His
Sir,
dependent sister.
Sir, if I record 2014, he had retired, then it will be error apparent on the face of the record.
Yes.
2014, what was he?
He was a teacher in the primary school.
Then 20,000 is correct. Then giving an opportunity in 126(2).
Yes.
So what better can be done?
Because
So now if
trial
after his retirement he may file, but retirement is a interesting thing. That again somehow we are again and again visited with the same proposition.
the liability of husband was not considered because of the expiry order.
Liability, why the claimant has to be considered?
Both.
No. Suppose the husband renounces the world and says that I will donate the entire 20,000 salary to the school. A very good purpose is for benevolent. Can the court, it's a liability, pious liability. Can the court look at that since he has donated 20,000 for children education?
No.
So obviously, so liability as far as the lady is concerned, so 25% is 5,000.
Yes.
This court has held 25,000 for 25%. Two decisions are there.
Because in view of the earlier, in view of the...
And he retired in which year?
I cannot say.
So obviously, I mean...
Now the liability is that
he retired
his
in the year
unmarried sister.
So 2019 you could have filed petition.
Yes.
Appellate court cannot take a subsequent event into account, and much less in a revision.
Because I was not given opportunity to contest that case.
Sir, by contesting, I'm asking you, you have to show actual prejudice. Administrative law principle also applies here. By contesting, you could not have said that your salary is less than 20,000 or you are not a teacher.
No.
That's the problem. The liability has to be, liability to pay the amount,
Yes.
you could not have denied.
No, because I was paying.
And if you consider 91,300 and 2014 is 23 years.
23 years.
The increase is up to 4,000, less than 25%.
Yes.
When nowhere there is a, rather if you would have contested, the hour would have been 6,000.
My only submission was that
Because
in the earlier
conservative, the court was conservative. So now you have to say that what you would have said, but that your salary is not 20,000. You are not a teacher.
Salary is not the...
You are found liable to pay 300 to a person. In 2014, the minimum wages were...
a declaration was there in the compromise petition that the lady will not claim any amount.
Can this court give a imprimatur? Suppose they agree for to commit a crime. It is as bad as committing a crime that legal right, the court will direct you to waive your legal right to claim maintenance.
Legal right is also there.
Yes. So any agreement contrary to provision, inconscionable contract. You entered into inconscionable contract.
A decrease there.
Don't rely on, because that contention has to be outright rejected. That the two persons entering into agreement. You put a gun on somebody, says that you declare that you will waive your fundamental right. He writes that you enter into an agreement. It is as bad as entering into an agreement to defraud somebody or do some illegal act.
Cancer patient is now dependent upon this husband.
Sir, that petition you have to file. That petition you have to file, adduce evidence.
Yes.
Something unfortunate happening to any case, that cannot be a matter of consideration in 2014.
Yes.
You must not be paying, mister. That is, it looks from your attitude, you must not be, your client must not be paying. Is there any stay order?
No, first order, first assay order.
Nothing is there. Either today, consideration on merits and disposal, or adjournment. This is not a but I'll record. Since we have spent time, I'll record the submissions and
read another date.
Okay. The revision is sought for the revision of order dated. Sentence change करिए काटी लेखन तो. Kindly take your seat. I'll take some time and dictate. Revision of judgment dated 17/11/2014. Rendered by the Learned Judge, Family Court, Cuttack, in criminal proceeding number 60C of 2011. Stop.
Interim judgment in the criminal proceeding 70/14.
Prayer, kindly look at the prayer. I have developed this habit to go by, look at the actual pleadings. Where is the date?
Is a mistake.
No,
One of her mistake.
sir, I don't wish to paint everything black and white. So your pleadings has led to this. Order dated?
Order dated 16/11/2021.
16/11/2021. Past it, so बाकी ठीक अछि. ହେଲା? ସେଟା ଠିକ ଅଛି. ଠିକ ଅଛି. ସେ page ଟା କୋଉଟା ପାଇଲେ ଆପଣ? 16/11 ଟା, because the other problem is that with the scan copy they don't give the dates. ସେଟା ନାହିଁ ତ ଯେହେତୁ they have not given it.
Infant order is page 16.
16. 16.
Yes.
Yes. कौन लिखे? सेटा सा ठीक है ना? 21. 16/11/2021. 470/2014. ସେଟା କହୁଛନ୍ତି ତ?
Yes.
ହେଲା? Stop. By the said judgment, the petition filed by the petitioner, husband in the marriage, under section 126 into bracket 2 of CRPC, to set aside the ex parte order dated 17/11/2014, passed in CR.P. number 606 of 2011. Contract Act गाड़ी में पड़ेगा, है ना? Indian Contract Act. कौन लिखूं तू? कौन लिख ले? सेंटेंस को कौन? Who says it? Sentence टा आरंभରୁ पड़ेगा ना? So and so was dismissed. Perusal of the judgment, improved judgment, indicates that the petitioner had taken a plea of not taking steps from 10.07.2014 to 23.11 dot 2011. Due to financial crisis. The petitioner had produced a medical certificate claiming that he was ill for the said period, but admitted in his cross-examination that he had performed his duty as teacher in the government school from 10/7/2014 to 23.11.2014. The further plea taken before the learned Judge Family Court was that in the settlement within court, in the settlement oblique compromise petition, that is captioned in vernacular as Rafanama within court. The wife in the marriage had put her signature, agreeing to a condition that she would never claim any enhancement of maintenance that was awarded in 2000. That was awarded in 1991.
95. 91 no case.
95 are in the criminal proceeding number 574 of 1991. Apparently, the plea of financial crisis substantiated by medical certificate fell apart upon the cross-examination of the petitioner that he was doing his duty as teacher in the government school. At paragraph 5 of the judgment, dated 17/11/2014, regarding award of 4,000 by enhancing the amount of ₹300 pursuant to the claim in the year 1991. The following has been indicated. Para 5, page 11 quote करते ना. There's been a further factual finding has been given by the court that the salary certificate of the petitioner husband shows that gross salary in the year 2011 was rupees 20,109. And the learned Judge Family Court had taken into account the cost of living in the year 2014 to enhance the amount to 4,000. Section 28, though the learned trial court has not gone into the aspect of compromise decree, that restrains the wife from claiming any enhancement. It would be apt and appropriate to refer to the provisions of Indian Contract Act, 1872, which provides at section 28. Section 28 is reproduced here. Agreements in restraint of legal proceedings, comma void. পুরাটা লিখে দেবে। Assuming that the wife had agreed for the wife had made a statement in compromise that she will not claim any enhancement. If the said document is elevated to the status of an agreement, it is hit by section 28. The inconscionable contract, সেটা ওটা প্রভিশনটা দেখে দেবে। It has to be noted that the right that was being considered by the trial court emanates from the provision that is section 125 of CRPC, into brackets, since repealed, and substituted by BNSS, Bharatiya Nagariko Suraksha Sanhita, BNSS, since 2025. Such a section 125 of the CRPC has been enacted by the legislature which is which is attributable to the Article 15(3) of the Constitution of India. Mr. Ghasiram Burma is not appearing, Mr. Tripathi. Other side is the absent, I didn't mark that. Ghasiram Burma, PK Panda. Out of 16 ଆପଣଙ୍କର ଆପଣଙ୍କ item 16 ରେ ଚାଲିଛି ତ? Yes. Are ଆପଣ
Sorry, Milord, I thought that item 13.
Are it is just I thought that nobody has appeared, but when I looked at the brief, the list, then I realized that somebody appearance opposite party, Mr. PK Panda.
No. This is item 13.
13. Okay, yes. I'm sorry. So you have two matters. That was the. I'm sorry. I'm so sorry.
Yes.
कौन लिखे? सेटा अपन 13 ठीक कोड. Which is relatable? Which is relatable to the Article 15(3) of the Constitution of India. The Lord Counsel for the petitioner seeks adjournment to obtain instruction. All right. list in the week commencing next week.
1 week.
Other time, more time.
Yes.
List in the week commencing. So now, so March masare 16 or not
23rd.
23rd February level. See March coach actually. We commencing 9/3/2026. March 2nd is followed by 2 holidays.
Yes.
And preceded by 2 holidays.
Yes.
So you have to be conscious of that. Yes.
15.
Passover.
16.
Ajit Kumar Tripathi for the petitioner, Mr. P.K. Panda for the opposite party.
Last order may kindly be seen, man.
Assets and liabilities.
Yes.
So what I say that since it is very difficult to conduct trial or adduce evidence, assets and liabilities have to be taken up along with the examination of the
Other
parties.
evidence, other evidence.
And examination of the parties. What is happening? A person who is an engineer, works in Vedanta, files an affidavit, I am a commerce graduate, unemployed. Or he leaves his job to become a supervisor.
Yes.
So then this court has to issue, this is an experience in division bench. Issue notice, we have to issue notice to the Vedanta. Then they appear. Then they say that he's engaged by a outsourcing, I mean, service provider. He's an engineer, maintenance engineer, something, Vedanta alumina. So, I mean, that requires, evidence on oath.
Yes.
Examination in chief.
My humble submission is that matter.
No. I'll be still more humble to request both of you that you examine that, exchange the affidavit. That's the method I'm thinking to do.
Yes.
It may not be exactly the way it should, but it is proper method.
Yes.
Both of you exchange your predicts. So you arrive at a figure.
Yes.
Because when I am not examining anyone, not taking any evidence. So then how I will correlate all those details given in that affidavit?
Yes. My humble submission is that I have already filed
proceeding before a trial court. Please appreciate. Maybe 125, 25, 24, both, any proceeding.
neither of the parties filed any affidavit of asset and liability in the trial court. Neither the petitioner nor the opposite party.
What is the award? That you must understand.
No award.
No award has been made.
Yes.
So it has been rejected.
Rejected.
So rejection can be on many more grounds apart from filing because this also we have considered recently that I have considered that whether Rajneesh versus Neha mandates that if the affidavit is not filed, nothing can be awarded because the award is minimal 2,000, 5,000, 10,000. Like this case just now you argued, a teacher's salary is 21,000 in 2011. He paid 300 in 1991.
Yes.
2014 court awards 4,000. So, do you require any assets and liabilities for that? And that kind of time you require?
No.
You need not.
No.
And that is the reason the other coordinate, the division bench of Justice, Honorable Justice Sinha, in fact, never had that approach. Because asking someone to file affidavit and then without taking any evidence there, or they simply file affidavit without giving details or giving falsehood, both ways. So if you want, both of you agree, it will go, I will remand it for consideration by the court.
My humble submission is that.
Yes.
Because
I have no objection, but I have to take instruction, at least your lordship may.
Sir, that I do, definitely. Even if I'm confident on merits and I can dispose it off. But only thing is that this should not be kept pending because this involves either way.
I agree with your lordship.
Yes. When do you want, sir?
Your lordship may give me some time because
suggest karo.
March.
ठीक है. Mr. Tripathi has taken now in March, so he will not object.
Anyway.
Sir, appearance section. It is submitted by the Lord Counsel for the petitioner that both of you kindly take your seat. I'll just dictate. Listen to it. That opening sentence lekhantu. The petitioner wife is before this court. Challenging the order passed by the learned judge, Family Court Jajpur, in criminal proceeding number 116 of 2022. What happened? Challenging the order kati lekhun to judgment dated 04.01.2024 passed by the learned judge, Family Court Jajpur, in criminal proceeding number 116 of 2022. Correct? Stop. By the said judgment, the petition filed by the petitioner wife in the marriage, along with the minor child, minor child aged about 3 years, represented through her mother, under section 125 of CRPC. Seeking monthly maintenance, 10,000 per month for the wife and 5,000 per month for the minor child. Was rejected. But apart from raising other grounds of challenge, the learned counsel for the petitioner submits that the order, the judgment of the learned trial court, the learned judgment, the judgment of the learned family court dated 4/1/24 would indicate that both the parties did not file any affidavit as mandated by the Honorable Supreme Court in Rajneesh versus Neha. Citation they did. Rajneesh versus Neha. Yeah, INSC, AIR, wanted. The learned counsel for the opposite party endorses the fact that no affidavit was filed. Pursuant to the direction issued by this court, kebe direction hai? Tripathi, you were referring to that order where there was a direction to file.
No direction was there, but I submitted affidavit of asset and liability with another petition for acceptance. Here before this High Court.
Before this court?
Yes.
IA number 113 of 2025 has been filed by the petitioner for accepting affidavit on behalf of the petitioner. You are filing both or only yours affidavit? What you are filing? You are filing indicating assets and liability according to you?
Yes.
Yours and the other side or only yours?
Other side also.
Achha.
Because the affidavit format is there.
Correct. Upon the format, if it remains unfilled.
Yes.
That I am asking you.
Yes.
By the affidavit affidavit shown to by the petitioner giving assets and liability of both the parties in the format required by the judgment of the apex court in Rajneesh. Supra. Stop. Para. The learned counsel for the So Tripathi, you take your seat. Learned counsel for the opposite party does endorse the fact that none of the parties filed affidavit indicating assets and liabilities before the trial court. it is in the fitness of the things and in the interest of justice, it would be appropriate. The affidavit filed by the petitioner and that would be filed by the opposite party should be considered by the learned judge family court. Jajpur. At the first instance, for which the matter can be remanded. The learned counsel for the opposite party seeks and has adjournment list in the week commencing. Arada kete rakhile 9 re 9 week re. Item 13 ra kebe rahila?
No.
In the week commencing 9/3, Mr. Panda. Enough time.
No, sir.
Yes.
17.
My lord, I am for the
You are Mr.
S. Das, your
Mr.
lordship.
S. Das.
For
the petitioner, opposite party blank. Yes.
I am for the wife and the minor son, your lordship. This is a matter regarding prayer for enhancement of maintenance in the 125 proceedings. My lord, admittedly, there is a delay of 265 days, my lord, because the wife had to procure the documents, lordship. I actually, if lordship may allow me, my lord, I wanted to take instructions in the matter regarding the actual amount of maintenance received, if my lord may permit me some time. Because this is a lawyer's brief, lordship, so I have not been able to take instructions from the client, my lord.
And in case of lawyer's brief, in case of maintenance, they will never apprise you regarding the quantum of maintenance received. That is also very interesting.
Lord, that is why I wanted only some time.
Anyway,
I only wanted to take instructions. I could not take instructions from the client.
You need not.
So that is why I wanted to take some
instructions. The IA is for?
Condonation of delay. Yes, your lordship.
So you take notice?
Lordship.
So is that you take your seat.
Lordship.
The petitioner wife is before this court seeking enhancement of maintenance granted by the learned judge, Family Court Baripada. In a petition filed by her along with her minor child from the marriage under section 125 CRPC, seeking monthly maintenance from the husband in the marriage. Stop. By the judgment dated 16.04.2024 in the CR.P. case number 127 of 2022, the Learned Judge Family Court has directed for payment of monthly maintenance at the rate of 6,000 for the wife, 6,000 per month for the wife and 3,000 per month for the child. From the date of filing of application, that is 19.08.2022. ऊपर जो लिख लेनी आईए लिखी हुए आईए एंड so and so आईए एंड आरपी फर्म the revision application has been filed after a reported delay of 216 days. Had learned counsel for the petitioner issue notice in the IA as well as the revision petition. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days.
Not 5 working days.
Within 5 working days. So para it is further directed that the petitioner and the minor child shall continue to receive the amount of maintenance as directed by the Learned Judge Family Court without prejudice to their rights and contentions as raised in the present application. Yes, next. But you please obtain that instruction. That is crucial. Yes. List in the list after S, sir, liberty to mention.
19.
पास कर दियो तो 22 पर है आउ थे सबुडा का कॉल कर देबे 19 years please
19 in this case I'm appearing for wife Miller.
Yeah.
And here I have received the notice without any document, without any annexure Miller. Yet there is a delay, notice of condonation of delay IA.
So the notice is not issued in the IA and the an RP firm together, separate.
No, only there is a condonation of today.
Subhasis Mahapatra for the petitioner, you are Mr. Misra.
Subhasis Misra on behalf of Subhasis Mahapatra.
Mr. Subhasis, you have power here, yes, Misra? Mr. Subhasis Misra for the petitioner, Mr. Mahesh Das for the opposite party. Learned counsel for the opposite party seeks for a copy of the petition along with annexes. Serve within 3 days. The learned counsel for the petitioner shall serve the same within 3 working days. List for orders in the week commencing. So, or earlier you want?
Yes, he is the
Mr. Mishra, when do you want?
16
rupees. Yes. Within 5 days, 5 working days. Yes. Yes.
20.
Mr. Vijayananda Das for the petitioner.
The petitioner is challenging the order of ex parte order in criminal proceeding number 207 of 2022.
What is the defect?
Defect is the delay because the person is serving in military, Indian Army.
No.
So 143 delay, madam.
The certified copy filed?
No, certified copy not filed because the entire case records sent to the Bhadrak district court for scanning. So he is unable to appear.
So you have to obtain that scan copy. You can take time.
There is
but that defect cannot be. High Court doesn't permit this. I don't have power to condone that. Non-filing of certified copy.
Because I applied the certified copy.
So for that you take time. You may take 6 months time or 6 years time. That's one way of looking at it.
No, because
6 days time.
Because
if you ask me to pass a order, that I will not ask for a certified. I will exempt filing of certified copy is not possible.
After getting certified copy, because all the records are sent to the Bhadrak court.
Sir, do you realize that?
We apply for certified copy, but it has not been obtained, my lord.
Sir, for that you will get time for 6 days, 60 days, 6 months, or 6 years. That's another thing. But how can I exempt that? That I'm asking you.
Yes, ma'am.
I cannot exempt. Those are not condonable
because I submitted the
certified copy, deficit court fee.
I submitted the Xerox certified copy of the order.
Sir, authenticated copy if you have received, free copy you have received, that is a possibility. But
because you
have to seek for time, but don't seek dispensation. If you seek dispensation and insist for it, it cannot be dispensed.
Delay, ma'am. Another miscase, my lord. That is
no. At least the delay part, notice can be issued, and the period taken in getting the certified copy has to be condoned.
Yes.
No difficulty there.
Take time. I am permitted to take time for obtaining the certified copy of that.
Apna dispensation में time मांगी नहीं की?
Dispense रे
you are colliding with the dashing on with high speed or what?
No.
In section 5 dispensation file ko number 58. What is the prayer?
Yes, sir. I have asked. Because yes.
Okay, I am granting you time.
Yes, my lord. It shall be submitted in near future. I have already in that.
No difficult. Prayer portion nahi sita.
Sir,
but that can be granted.
Yes, it shall be submitted in near future before this Hon'Ble court.
Yes.
Because the
difficulty 8 of 2026. The IA 58 of 2026.
Yes.
IA 58 of 2026.
Yes.
My voice is not coming.
Yes.
The IA has been filed for dispensing with filing of certified copy of or the impugned judgment dated 08.07.2025. At 25 passed by the Learned Judge Family Court, Kendrapada, in criminal proceeding number 207 of 2022. So, High Learned Counsel for the petitioner, he submitted that. He had the application for upon enclosed certificate copy application.
It will get enclosed.
That you should have filed.
Yes.
Application को extra copy अच्छी.
Extra copy.
They do. और लिखले High Learned Counsel for the petitioner. He should attested करी दियो. He देखे अच्छा ठीक है.
Sir.
He produces photocopy of the copy application dated 21.01.2026. এখন দেখা যাবে 21 না 71
21. আচ্ছা ওটা কপি আছে হ্যাঁ
21 মান
yes
তো কোন ওভাররাইটিং ইজ কোন লিখলো দেন কোন লিখলে কোন 2020 which is taken on record. They submitted that due to transfer of records from the court of Kendrapada to Bhadrak
for scanning,
for digitization and scanning. For scanning and digitization.
Yes.
The certified copy has not been made available and further time may be granted. Accordingly, further, how much time, Mr. Das? 6 weeks, 4 weeks?
6 weeks.
Please, further 6 weeks time granted for filing of certified copy. The application is disposed of. Liberty to mention. Whenever you get it, you file.
Yes, sir. Obliged.
Next, correct.
Item 22. 22.
Yes, please. So, Satyabrata Jena, you are Mr. Jena.
Yes.
Satyabrata Jena for the petitioner.
Challenging the petitioner, a question 2023 passed by the Learned Judge Family Court, Jajpur under section 25 CRPC, Ministry in criminal proceeding by the judge Ekoshi and execution 53 by the other Teishi for maintenance.
Yes.
The petitioner demand increase the maintenance because she has one daughter, her age is 13 years, and her one son, her his age is 5 years. But also, the opposite party already married to another person in 2021 without any divorce, my lord. The opposite party did not maintain proper the maintenance monthly.
So execution, what happened to execution?
My lord?
What happened in the execution?
I demand here 4,000 to 10,000.
So have you
price is high.
Have you put into the put into execution the decree granted earlier of rupees 4,000 and 1,000? प्रथमे केते पाइथिले
88,000 रु से 48,000 देइछि आउ दउ नाही अद्याविधि
अरे से आपण से ताको तू कहउचंती तू तो आपण भी काहे कहउचंती आपण तो एटलीस्ट एज ए लॉयर यू शुड नॉट कहबे 28,000 रु 29,000 देइचंती
48,000 देइछि आउ 40
कि जोटा आपनकर एग्जीक्यूशन रे पुट करिचंती कि
हां सेतरे मात्र 1,000 2,000 हां देइछि
एग्जीक्यूशन में कोन ऑर्डर हैला एग्जीक्यूशन में कोन ऑर्डर हैला
एग्जीक्यूशन ने ऑर्डर हैछि
कोन पेज रे अछि
आगे
को पेज पुष्टा केते
2,000 1,000
इट्स बड़ा ब्रीफ कोन ब्रीफ तो आरंभ होइछि आज्ञा एक गुरु सरीछि 53 रे आपण 2000 पेज कोन को अच्छा अच्छा, I'm so sorry.
Ear problem. So I
नहीं
listen properly.
ठीक अच्छी मो वॉल्यूम बढ़ी दियो मुझे भाबुची कौन है correct? Sir, you have put into execution the decree.
Yes.
Have you put the earlier decree जोटा आपण से decree satisfaction पे execution करछंती की?
Execution କରିଥିଲି
से कौन हैला?
ସେଟାରେ ଅର୍ଡର କଲେ ପା ଆକୁ ପୁଅକୁ 1000 ଝିଅକୁ 1000 ମାକୁ 2000 ସେ 4000 ନଟ
सर execution में केमती बढ़िबो?
बढ़िला नहीं
enhancement petition गोटे आपण enhancement धरंतु 125 लिखला
आज्ञा
subsequently आपण ताको enhance करि परिबे 126 पदे 126 2 की केता अछि सेटा अछि ता परे परे अछि don't go by my words, I'm just telling it. So that you filed for enhancement or not?
and
then how you are agreed then?
come to
I hope you आपण 25 जेंति अछि you do matrimonial cases
125 CRPC 29 4 we are 19 4
Mr. Jenna.
Yes.
You do 125 cases?
Yes.
And 125 also. So there is a provision contained in the statute itself for enhancement.
Annex 2 is execution order 53. Annex
Execution, I am unable to understand, sir, how a decree in execution, the amount can be enhanced. Earlier execution, it will be
area 88,000, but also pay 48,000. This is the execution proceeding filed today to release of area maintenance of some 88,000. The record reveals that the opposite party strength through DW with the 88,000 coupled with the NBW was arrested and detained in civil prison for a period of 30 days due to failure in payment of such maintenance dues. The petition was directed to file the list of landed properties for attachment of which immutable properties by the district collector, Jadpur, but she failed to comply with such order. There is no other mode of realization of available to this court for releasing the above maintenance area, considering the fact that the petitioner had been already detained in civil prison for 30 days and no additional claim has been filed in record to issue new warrant against him. I deem it just and proper and close the proceeding and the proceeding is closed.
Have you filed the assets affidavit? That I was going to ask you.
Yes.
The judgment debtors property details. When did you file? By which application?
No, the police not take any action.
Police का action नहीं बे.
Police ताको arrest करके ये कले.
Civil imprisonment is a consequence. Penal action. What for realization of the amount? Have you furnished the details of the properties before the court for attachment and realization as auction of property? Auction of property. It can be. It will be realized as a revenue demand. Have you done that, sir? But the court, the order doesn't suggest.
Kindly issue the notice to the
no.
party.
I'm kinder than you. But as far as passing illegal orders, that doesn't match with kindness. I should not be kind to pass illegal orders. I have to understand what you are saying. Sir, have you filed the details of the property for attachment?
No.
Then I cannot pass a impossible order.
No, only notice to
you must understand,
pay the area.
You have some difficulty. Don't be fast. First you realize what you are submitting.
The opposite party already married
Sir,
to another lady.
Sir, opposite party marrying another lady doesn't aggravate the 125 or 127. So make a legal submission. We are not playing to the gallery. Though we are live. By saying 10 times that opposite party is married. So that is not a proviso in 125 or 126 or 127. You want to enforce a decree or not? Money decree.
125.
125 is a money decree you want to enforce.
Yes.
So when did you file the list of property? Because he punished civil imprisonment.
Yes.
So he has preferred to become a state guest. Correct. So now you have to bring to the notice of the court the details of the property. Where is that? You have to tell the.
I will give you.
You have
the petitioner will submit the details.
Yes. Otherwise, if the decree holder does not give the property details of the judgment debtor, how the court will act? Just go back to your pages again. Look at page 22.
22. Yes, my lord.
So kindly mark the order dated 14/11/2023. At page 23, conditional NBW is issued.
Yes.
Don't use your spit on the pages. That is Vidya. That doesn't improve turning of pages. It's a bad habit of touching the. Neither the tongue is getting twisted, nor the page is getting lifted. This is a habit of putting. Don't do that. Leave that habit of putting and again touching the. So now conditional NBW is issued.
Yes.
Okay. Then he is produced before the court.
Yes.
So then his conditional NBW 88,000 area.
Yes.
Look at page dated, order dated 18/12/2023. Pile
23.
Again. Page 23 re order dated 18/12/2023 अछि.
23.
18/12/23.
2023.
14/11 ରେ ଆପଣଙ୍କର ଇସ୍ୟୁ ହେଲା conditional valuable warrants.
18/12/23.
हाँ.
18,000.
So he is directed to
for non-payment of maintenance allowance or until the payment.
Correct. So now he is arrested, detained, and he's arrested, produced before the court. The court says you pay 88,000. He doesn't pay. He's sent to sent to civil imprisonment. Order dated 18/12/23. Now.
The petitioner want to increase the maintenance.
Which provision?
Provision market price is already high.
Sir, which provision in law? That I've been asking you. There is some difficulty for you to listen.
Similar case, I have some similar judgment also attached here with the Supreme Court and Delhi High Court. Similar case already attached here with judgment.
So, Jenna, which provision in CRPC provides for enhancement? अपन जितने दिल्ली हाई कोर्ट और सुप्रीम कोर्ट जजमेंट पढ़िले सीआरपीसी पढ़िबेनी
पढ़िछि
ताल पढ़े गला बही कहीं
पढ़िछि सेते क्लियर मेंशन करछि दिस मैटर मैच विथ दिस मैटर
आपण एनहांसमेंट चाहउछंती ना कोर्ट रे समान अपचय करे
एनहांसमेंट चाहउछि
को प्रोविजन में करिवे
provision সেটা কোন ভাবেটা ওই অর্ডারটাକୁ ଆପଣ increase କରିବେ
ଆପଣ ପ୍ରେୟାର କଲେ କଣ ହବ? ମୁଁ କଣ ଏଠି ତଥାସ୍ତୁ କରିବାକୁ ବସିଛି କି? ମୁଁ ସେତେ ବଡ ନୁହଁ, ମୁଁ ଗୋଟେ ଛୋଟିଆ, ମୋର କିଛି କନଷ୍ଟିଟ୍ୟୁସନାଲ ପାୱାର ଦିଆଯାଇଛି, ଆଇ ଏମ୍ ଫଲୋଇଂ, ସୋ ଦ୍ୟାଟ ଇଜ ଆଇ ଏମ୍ ସ୍ପେଣ୍ଡିଂ ଟାଇମ୍ ୱିଥ୍ ୟୁ।
my lord
ଆପଣଙ୍କ ଡିଫିକଲ୍ଟି ଅଛି, ଆପଣ ଆଟେଣ୍ଟିଭ ରୁହନ୍ତୁ, ଆପଣ ଆଟେଣ୍ଟିଭ ରହୁନାହାନ୍ତି। ମିଷ୍ଟର ଦାସ, he has some difficulty in hearing, so just don't make any background. He is unable to follow actually. Sir, Mr. Jana. Oh, acha. He is seeking your assistance. Okay, he will be happy. Mr. Das, kindly listen then.
Yes.
So, he filed a 125 petition.
Yes.
It remains decree, I mean, money decree is there. 88,000 is due.
Yes.
The court conditional bailable warrant is issued, 88,000. The person chooses not to satisfy that, he is held behind bar. So he is, now becomes a state guest. So he is treated there for 1 month.
For a particular period, he will be there and again he will be
So
released.
now the next stage is, for enforcement of the decree, he has to furnish the detail for attachment of property and auction.
True.
So first part is coercive measure, he has arrested, so he prefers that to do that.
Yes.
And for 88,000, in today's world, 88,000, somebody prefers to go to, jail is very unusual. What Mr. Jenna is arguing, that he wants enhancement. I have been explaining him that there is 127 CRPC petition, if you have filed for enhancement, what is the result of that? That he is unable to.
Your lordship can have jurisdiction straight away.
127 nahi.
Yes.
That's right also. No, execution also, executive court cannot also, Mr. Das.
No.
Executive court 126 that he cannot. No.
That cannot. He has to file his enhancement application.
126.
Yes,
127 he has to
court
file.
of action.
So seta tike kotha hobo.
The court will assess.
Upon
And probably my friend is arguing something, but which is being prayed is something different.
No, sir. Sir, actually, unless he files a 127, so this behavior of the judgment debtor has, he is also confused now.
Yes. He is taking advantage of some sort of lacuna from this side. Might be. But here, I will just assist him.
Yes, 127 got a bujhe debe. Then kindly take page 26.
Yes.
Now you are the counsel.
I will try to assist you.
No, he has to, he requires your help.
Page 26.
Order dated 14/7/25.
Yes, madam.
Just, you can read it fully. That's the only portion. 10 lines.
Yes, the Learned Trial Court has exhausted his limit and he has directed.
So that is one aspect.
Yes.
So if he has filed a 127 petition,
Yes.
I think he has not.
No.
Most likely.
Yes.
So these two things kindly explain.
I will assist him.
So I'm passing it over.
Yes. Yes, madam.
Yes. Next. ଆପଣ ବସି ଯାଆନ୍ତୁ ଆପଣ ଯାଇକି kindly take your kindly have your seat there. Next call କରନ୍ତୁ ଆଜ୍ଞା.
Next item is your lordship's is mine.
Oh, acha. I'm sorry. I thought that yes.
It is in fact a covered matter, but it is relating to that closure of.
ସେ ପଳେଇଲେ କି ତା matter ଟା ଆପଣଙ୍କ ଲୋକଙ୍କୁ ପଠାନ୍ତୁ. ଅଛନ୍ତି 500 ଘର ହେଇଛି ବୁଝିଲେ ତ
ଆଉ ଥରେ ଡକା ହବ.
ଟିକେ just give some time to Mr. Das and me also. Yes.
ମୋର ଏଇଟା ହଉଛି 23 item 23.
The batch of case was disposed of. Now I have got the instruction today, Lord.
with the Parvai's comment, the judgment passed in the common judgment, that was under challenge in writ appeal. That is my writ appeal 76 of 26.
Writ appeal କିଛି order ହେଇଛି? Simply file କରୁଛି.
Yes. So,
So, Mr. Das, after being recalled, it has been restored again.
yes.
So that it has been marked to the, now I have the determination.
Your lordship is now this
So,
matter
that's
is
it.
for your lordship.
Okay.
Now only.
So, I mean, Honorable Chief Justice's minutes are there, so I wanted to check that with you. Yes.
Now this case is before your lordship.
So now, Mr. Sahoo.
I'll file my
Correct.
short affidavit, whether it is federal.
No, I'm not passing any order against anyone for that matter.
I have
Not
gone through that order.
So one thing is that, so should I pass that order and you will go in writ appeal, or we'll wait for writ appeal to be decided?
That I'll file my affidavit.
yes.
Yes, I file my affidavit saying that this is what
The writ appeal ଟା ଖାଲି just file ହେଇଛି. ତାର defects remove ହେଇନି. Diary number ରେ ଥିଲା ବୋଧେ. Number ହେଇଗଲା.
Yes.
It has not been placed before the honorable court.
26 of 26.
Then we can wait for that.
Wait for some.
Oh, that would be
ideal for the petitioner.
It will be wiser.
Yes, if it is.
Petitioner also.
Yes.
The petitioner will be, yes. Mr. Saubhagya Sundar Das for the petitioner. So PK Sahu for the AC for the opposite parties. Pursuant to the order dated 27/11/2025, the allotted AAC has obtained instruction. Stop. He submits that writ appeal number.
Writ appeal.
Consider 76 and 57, 76 and 77.
But a कागजोटे लिखी दे दे.
Again.
कागज दे. ଆପଣଙ୍କ ଅର୍ଜେଣ୍ଟ ପ୍ୟାଡ୍ ଅଛି ନା ମୁଁ ଦେବି? Writ appeal number ଏତେ he will give you the numbers ହେଲା. ଆଉ arising out of ଟା ଲିଖିଦେବେ. କୋଉ ରିଟ୍ ର ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି?
That's a batch of case. Oh, common.
No, ଦିଟା ରିଟ୍ ଗୋଟେ 10985. It is
10985.
Yes.
That
writ you can give.
There is
Writ appeal ଏତେ arising out of WPC number ଏତେ.
Yes,
is pending adjudication before the court. Awaiting consideration and orders in the said writ appeal, the matter is adjourned sine die. Liberty to mention.
Yes, madam.
Good. Yes.
24. 24.
24 ଟା ଟାଇମ ହେଇଗଲା। ଆଚ୍ଛା ଆପଣ 500 ଭୋଟ ତ ଫ୍ରେଶ ଡାକିଲେନି ଅର୍ଡର ଗୁଡାକ ନା ଲାଷ୍ଟରେ ଡାକିବେ ନା କଣ? ହିୟରିଂ ଆରମ୍ଭ କରିଦେଲେ ଫେରେ ଅର୍ଡର ଡାକିଲେ କଣ ହବ? ଠିକ ଅଛି। 24 petitioner none, Mr.
No, I am
Mr. ମିଶ୍ର ତ ଆସୁନାହାନ୍ତି, ସେ ମିଷ୍ଟର ରଥ ଆସୁଥିଲେ ନା, ସେ ବି କୁଆଡେ ଗଲେ? 24 ଲେଖିବେ, the matter is listed for admission hearing. ହେଲା? None appears for the parties to grant further opportunity, list in the week commencing 6/4/2026। ଆପଣ 2015 ମ୍ୟାଟରକୁ କେତେ ବାଟ ନଉଛନ୍ତି? ସେ ଏଗେନ୍ ସେମ୍ 25 ମ୍ୟାଟରକୁ ଆଣିଛନ୍ତି ଏବେ, 15 ମ୍ୟାଟର ଟିକେ ଟିକେ ଇୟର ଗୁଡାକ ମାର୍କ କରନ୍ତି ନା କମ୍ପ୍ୟୁଟର ଚେଞ୍ଜ କରିଦବ? ୱିକ୍ କନେକ୍ସିଂ 23/3/2026। Yes.
35
I got the old instruction is there, but petition is not there. The claim of the petition that he could not make application, online application. But what I found from the instruction is not eligible. That is why the online application was not accepted. Two things, Mr.
Sahoo,
Again.
2017-18 entrance examination that should be the first contention.
Yes, I'm saying.
In 2026.
It's not there. Yes, there are two grounds here. I found one is age. He has crossed the age limit. That is the specification in the advertisement. 30 years inclusive of the relaxation. But by misinterpreting that I am an ex-serviceman, I will get more. He has stated. And the second is elective subject is not Hindi. So in two way he's
Okay. But let us not go detail into the merits right now.
Right. Yes.
Let us record your submission and petitioner. आप order active. Mr. Petitioner done, Mr. P.K. Sahoo, Additional Standing Counsel for the opposite party. The matter is listed for admission hearing. None appears for the petitioner when the matter is called. Learned Additional Standing Counsel refers to the instructions dated 29.6.2017 received in the office of the Advocate General pursuant to the directions issued by the court. This you file with a memo at a photocopy paper.
I have got extra copy. That or I can also Xerox copy is also with me.
Give that file a memo. Original,
two originals there. I can also.
You can keep it. No difficult. If I say memo enclosing the said instruction, it has to be noticed that the writ application was filed in the year 2017 with a prayer to allow the petitioner to fill a form for admission to H ED course for the session 2017-2019. By interim order dated 20.06.2017. Interim order dated 20/6/2017, the coordinate bench had directed for accepting the form of the petitioner manually to be filed on 21/6/2017. Thereafter, though the matter is listed, was listed on before the Lok Adalat, before the National Lok Adalat on 13/7/2019, and before coordinate bench on 28.08.2025 and 11/11/2025. There is no permission on behalf of the petitioner that in fact he has filed the application manually as directed by the interim order dated 20/6/2017. List in list आज केते तारीख होची 4 तारीख list in the week commencing पर डेट कर देला ना week कर दी list on 10/2/2026 for orders indicating that the matter shall be disclosed of. The registry shall intimate the next date of listing to the learned counsel for the petition. So 2017 रे फोन नंबर नथिले कोन आपण डायरेक्टली देखि फोन करिवे अरे आपण जो आस्ते आस्ते कथा होचि कोन छथि कोन pass over Mr. Jenna's matter Article 22.
This case, your lordship may grant him liberty to withdraw and approach the appropriate.
Liberty not necessary. 127 is independent right.
So it is independent right.
It's independent right.
But
But and I think there is not the delay also.
And pressing this application will not serve his
So
purpose.
he will be in further problem.
Yes.
I mean, the petitioner
Yes.
is unable to furnish any details.
Yes.
So she is unable to enforce.
And by the
So
time
now he will take the plea that the matter is pending before High Court.
So it will be rather disadvantageous to the petitioner.
And you,
the time when he could have come before this honorable court is gone now.
And the other part, Mr. Jena, just explaining that she must furnish, she must continue the execution, furnish the details,
Yes.
property details. Even immovable property can be attached.
Yes. And here they have
Court will take care of it.
And the gentleman is only 2 years old in the practice matter. That is why probably the benefits of the bar he has not taken it.
Yes. Now he is enriched by thanks to your intervention.
Yes. So let him be granted the leave and withdrawal of petition. Yes. Grateful to assist you, Lordship.
Thank you. Mr. Satyavrata Jena for the petitioner. Opposite party blank. The learned counsel for the petitioner was heard at length. The learned counsel, Mr. Saubhagya Sundar Das, was requested by the court to assist as amicus, particularly for the reason that the issue involved being nuanced. His experience would help in adjudicating the matter. Mr. Mahapatra, anything else? Senior Mahapatra? Or this much is enough? Yes. The matter was passed over after hearing the learned counsel, Mr. Jena. The petitioner wife in the marriage is before this court, seeking a direction for enhancement of maintenance from 4,000 awarded by the learned judge, family court, Jajpur, by judgment dated 24.03.2023 in criminal proceeding number 191 of 2021. You can take your seat, Mr. Jena. Sit down. I'll take some time in dictating. Stop. The said petition was filed under section 125 of the CRPC. By the wife in the marriage, along with her two minor children from the wedlock, represented by their mother. Section 127 of the Code of Criminal Procedure, 1973 into bracket. What did I cut on to? Whatever. You put out with it. Sit, little bit there. Correctly? Since repealed and into bracket since repealed provides thus 127 तक quote कर दो है ना तापर लिखिए perimeter provision has been made in section S.146 section 146 of भारतीय नागरिक सुरक्षा संहिता 2023 पर the petitioner has liberty to move the appropriate court for seeking enhancement of the amount awarded by the Lord Judge Family Court by judgment dated or in judgment dated 24.03.2023. The petitioner shall have further liberty to move for execution of the said decree. Execution of the for execution of the judgment, which is in the form of a money decree, by furnishing the property details of the judgment debtor before the executing court. The petition is disposed of accordingly. Yes.
26.
Item 26, my lord.
Yes.
But the petitioners, my lord.
Mr. Srutiranjan Das for the petitioner. Mr. Suryakanta Dibedi.
SS Das on behalf of Mr.
Mr. SS Das on behalf of SK Dibedi for the opposite party.
Part 1.
Yes, please.
I have to file rejoinder in this case, my lord. 3 weeks time may be granted.
Counter file.
Counter file.
Copy, sir.
Copies of my lord.
The learned counsel for the petitioner submits that he may be granted further time to obtain instruction and file rejoinder in response to the counter filed by the opposite party.
Number 1, my lord.
As spread on filed by opinion number 1. Number 1. As spread for the matter is adjourned and can be listed in the week commencing 6/4/2026.
Interim order is there, man. That may be.
Interim order as passed earlier shall continue till the next date of hearing.
I am obliged.
25% direct hitler deposit ko jate.
Alright. That has been deposited.
Check it. If it is anything is there, just bring it on record. File that IA or affidavit, whatever.
Already deposited. Otherwise, that interim order would not be.
Yes.
Obliged. I am obliged.
Yes.
27.
अपना फ्रेश उड़ा तो पेंडिंग रख लिया पास ओवर करी रख ले कितना डाकियो तो
Password item 7.
अच्छा वो दूटा कहले मेमो पे मेंशन करते तो लिखियो पड़िबो ना तापरे मानिबे आ कोन काली आनिबे ना पर दिन आनिबे काली तो नाटा लेक्चर दिगी इट इज ओकिलो का नाटा आप लिखिए देवाशीष त्रिपाठी फॉर द पिटिशनर अपोजिट पार्टी ब्लैक 7. The matter was passed over as it was mentioned by on behalf of the learned counsel for the petitioner that she has no instructions. And memo to that effect shall be filed during course of the day. So, though the matter is called thrice over, the learned counsel has not appeared. Stop to grant further opportunity. List କୋଉ ଦିନ କହୁଛନ୍ତି? List on 6/2/2026. Yes. Yes, next.
Item K.
None appears for the ସବୁଗୁଡାକ after recess call କରିଥିଲେ. None appears for the petitioner, though the matter is called thrice over. Once when it reads, again after the resumption of the proceeding, and again before rising of the court. Stop. To grant further opportunity, list
We comments in law.
the borders matter that changing of nomenclature.
Basically.
List in the week commencing 23/2. And upon order से आनी same phrase ही रहेगा, but change of nomenclature. Yes.
15.
15 टा भी same 3. 3 थोड़ा calendar. ठीक है. Same order. ना. 15 टा same. केबे को देबे date? 31 प्रेस এইটা অর্ডারস নাই এটা ডিফেক্ট কোনটা আছে আচ্ছা ও 23/2 উই কমেন্সিং 23/2 ঠিক আছে
47.
24 is considered. Pardon. Item 24.
तो पिछले मिस्टर दिलीप राय फॉर द पिटिशनर ऐड कर दे
Counter
everybody is scared of you. The opposite party, because he cannot take sweets anymore. You should be selective in offering where the taking sweets is restricted. You should be careful in that. He's not coming. Nowadays, the senior is never coming. And what about Mr. Ratha? Have you seen Mr. Ratha? He's also not there. His name is not there, of course. But in all matters, you inform Mr. Ratha.
Oblige.
This is after notice matter. You have to take up of 2015 matter.
Counter region file कर देबी तो समय दे कौन से लोग
डर के आसु ना आपण रिटर्न फाइल करिवे ना 24 आवर ऑर्डर कर दियंतु मिस्टर दिलीप राय फॉर द पिटिशनर अपोजिट पार्टी स्टेट बिल्कुल पार्टी नहीं जो साउंड
एटा होची हमर ओयू
एसएस ताको ओयूटी संगरे का को चंदा ताको देखुचंदी
ना ना
यू कैन गिव ऑफर हिम ही इज हैप्पी देयर इज नो रेस्ट्रिक्शन फॉर मिस्टर साहू टू हैव इट The matters where state is a party, if you write non-apparent, there is a difficulty. You must understand that. Because they are present in court. No, maybe OP4, but I don't know. OP4 कृषि विज्ञान केंद्र is state.
सब
कृषि विज्ञान केंद्रटा होइयोटी काई हबो अपन चाषबास तो करते तेज थोड़ा केन जानिबे एलिटिस्ट लोक याडे रहले
हम एरिया तो चाष करिए
yes next order लिखंतु Mr. Dilip Rai for the petitioner opposite party none कर्नाटक मिहिर कुमार रथ MP रथ any idea what is his name
सुभाष
SC रथ Subhash Chandra Rath. Thank you. The learned the non for the opposite party. The learned counsel for the petitioner 6. How much time, Mr. Ray? 4 weeks time to file counter in response to the rejoinder filed by the OP number
Opposite parties?
All. One counter on behalf by the opposite parties. Hello. And, stop. Accordingly, the matter shall be listed. Date करूँ तो जल्दी ठीक है. Week commencing 16/3/2026. The registry shall intimate the next date of listing to Mr. Subhash Chandra Ratha, who usually appears for the opposite parties. Upon inform कर देवे. Yes.
47. My lord. This case is posted for final hearing.
Yes. Can it be completed within short time? Once we start, we should. Who is on behalf of which one, Mr. On behalf of Tripathi?
My lord, no, my power is 3, your lordship.
Achha, Mr. Sethi.
My lord.
Mr. Sushanta Kumar Pradhan, -3 for the petitioner, Mr. S.K. Sethi for the opposite party. So some mediation is going on. Why there is a direction by the court-led bench for personal appearance?
Settle is see pila interested अछि नबा पे गार्डियन टिके प्रॉब्लम करछन्ते
Interested नबा पाई किंतु मेंटेनेंस नबा पाई
नहीं बाहर को बाहरला पर
से कहबे तांकर इंटरेस्ट अछि मेंटेनेंस मागिबा पाई. So why do we start now? We should start collecting fund and in these matters and pay maintenance or what? Maintenance and mediation कौन है? अपन तो you are
सेटलमेंट पे ट्रायल कराया था.
This is order against
125.
125, but mediation can be made. And what is the amount directed to be paid?
Nil. Dismissed.
Dismissed. On ground?
Flimsy ground, your lordship.
Is it deep and dumb?
Oh, acha.
Only.
It is a very hard case. Hard and unusual case.
I have specific.
Both are different, but the problem is at times the avocation of we recently discovered somebody having
is it partial
crores of properties like begging, if I may say that. So we never know what is happening actually. Though I am not taking judicial notice of that, I am just what is the assets and what is the liability. Suppose a deaf and dumb person is having enough money.
Yes, money. He has a puja samagri dokan. 10 pala earning more. He admitted the same.
But local, can you talk, because the deaf and dumb, you need a sign language expert to explain them.
Yes, study.
What is the physical infirmity of the lady?
No, nothing.
Sure. She is the support for the husband.
Yes. Is ready to.
She is the salesperson in the. So she is not paid. The Sethi. Just check it with your. What is the? This is a very difficult situation.
That's why my lord has directed to present in the chamber, Justice Pati, and there capacity problem.
Unless there is a sign language interpreter, how can I express myself before a deaf and dumb person?
No, he has a.
After somebody coming here gets a little bit nervous. He is unfortunately cut off from the world.
And his father was present with him.
So you talk to his father. That way, and the lady can be support for her. I mean, she has some magnanimity. She has chosen to marry a person deaf and dumb. Definitely, she has the knowledge.
Admitted dowry has been taken 1 lakh rupees.
But in fact, it was the father of the lady who convinced the petitioner to marry her daughter.
They are relatives before marriage, and taken 1 lakh rupees as dowry. That's admitted in WS.
Father of the husband to marry the petitioner. I mean the opposite problem.
So position नहीं दुकान गलो पुनी से थ्रू.
Wife को पापा से convince करते ले वो marriage करिया.
Very difficult. If you think about it, it becomes very difficult actually. दुकान भलो चलची.
हाँ दुकान चलची.
The city you obtain instruction in this. Mr. Athras Lekle. As it is said, the facts are stranger than fiction. The case at hand is one of that variety. The petitioner wife married the opposite party, husband in the marriage, knowing that he is deaf and dumb. It is stated by the learned counsel for the petitioner wife that the father of the petitioner had helped the opposite party. You take your seat, I'll take some time in dictating. The father of the petitioner wife had helped the opposite party in starting a business of quote puja samagri at the Sopolla market in the district of Noyagad, Daspalagi Noyagad. Para. Considering the plight of considering the difficult situation faced by both the petitioner husband, wife and the opposite party husband, the learned counsel for the parties are requested to talk to the father of the opposite party, into bracket, as suggested by the learned counsel, to arrive at a amicable settlement. As it is stated by the learned counsel for the petitioner that the petitioner is willing to go.
Yes.
The petitioner is always ready and willing to resume the matrimony. Should we involve the district legal services authority?
ଯାଇଥିଲା ସେଠି ଫେଲ ସେଠି ଫାଷ୍ଟ ଆଗ ରାଜି ହେଲେ ସେ ବାହାରୁ ଗଲା ପରେ ବାପା ତାର କହିଲେ ନାଇଁ ନାଇଁ ନା ସେ ସେଠୁ ପଳେଇଲେ ସେଠି ଫେଲ ତାପରେ ଆସିଲା ରିପୋର୍ଟ ଫେଲ
or they should part ways. 13B is the way out. This become torturous. The kind of allegations made and all these things are torturous. That we should prevail. You can persuade the husband that he can have that kind of mercy with the lady who had opted to make him a life partner, realizing, knowing fully well that he is deaf and dumb because they are related, distant related.
He is ready.
The families are known. Of course, not within the prohibited degree of relationship. Sapinda, they are not sapinda, they could not be sapindas, but they should persuade that. This become a very complicated thing. And how much sacrifice you expect from a lady to this extent? You cannot. And as law could have it, they made an effort, both of them. You can't blame anyone in this kind of a situation. The husband is unfortunate. She is not having the best of life. He can't be blamed. Dekun 13B, Mr. Pradhan. 13B, go for 13B local council को कहूँ 125 DV Act इसुबरे पसंद तो नहीं 13B रे अपन को जदि किसी मिलिला किसी भाविबे अपन गोटे त्याग कले एते परिश्रम कले लाख टका देचन से लाख टका देले भी you should agree for that and part ways. अपन बर्तन को ना you do not have a matrimony but you are pursuing litigation. And which court will be persuaded to impose a decree on a deaf and dumb person?
No, he has income. Admitted.
Income is he paying income tax?
No.
Okay, simply, sir, common parlance says legal connotation is different.
That isn't admitted.
Common parlance discussions dilute this whole proceeding. That misdirects all of us, you and me. Say bhatta pauthibe suppose. He is entitled to bhatta. In the court impose that say bhatta ru diyantu. Cannot be. So it is for that, if they stay together, they possibly they will be enriching each other's life.
Wife is ready, always ready.
Otherwise, you part ways, that is better.
Yeah, wife is already
Let
ready.
us see. Let us see. With a hope that the learned council shall be able to persuade the parties to arrive at amicable settlement acceptable to both. The matter is urgent to be taken up, to be listed in the week commencing. Again.
Short date.
Short date रे आपण करिपरिबेनी.
हबनी तो सेटा.
आपण साइन आपण किसम छाडी दियंतु. साइन लैंग्वेज इंटरप्रेटर दरकार.
से कहउचंती ता वर्षेला छाडी दितलो से पुनी से प्रॉब्लम सेम.
16 मासे परे कर दियंतु. 16 3 20 26. By 16.3, prepare them for 13B. That is better. No, you have to explain that. This is not a litigation worth pursuing.
जैसे बर्डन गोटे पड़ले से कंप्रोमाइज हे जो सेंस.
आगे आगे.
बर्डन न पड़ला पन से
बर्डन कोन पड़िबे त कोन पके हबो. आपण तो देखले आई थिंक यू आर प्रेजेंट सिविल इम्प्रिजनमेंट 88000 टका पे मासे रहले जेल रे भारी खुशी.
ये राजी.
So that's the problem. The husbands, they behave very strangely. For 88,000, they go behind bar and there is some correlation. The learned counsel was hard of hearing. He could not understand what is being discussed. Yes, next please.
Okay.
Please, your lordship. Please, your lordship.
कपाट बंद करंतु से शब्द आसीबो से पूर्ण. Yes.
Please, your lordship, my lord. My lord, in the last occasion, your lordship was pleased to adjourn this matter today, my lord.
Yes.
As my restoration petition was sub judice before the Lorraine Trial Court, my lord.
Yes.
And in the meantime, I have filed the rejoinder, my lord, and I have sought the copy.
But suppose after restoration, you have to file this petition again, or this has to be pursued. This case has outlived its life. बुझिपारे.
For a moment, my lord.
एतरे वेंटिलेटर लगेले प्रॉब्लम कोन होय कहले थरे इंट्यूबेट कर देले आ भारी कष्ट हो वेंटिलेटर काढिबा. आपन तो वेंटिलेटर रे भी नाही. केस से जो वेंटिलेटर लागे कौन लागे. केस उडा के वेंटिलेटर लगाबे नी. एतरे कौन लगेबे आपन. You are seeking can you look at your prayer. CP 55 of 2021. For there you filed interim maintenance in section 24. CP has been disposed of.
Well, interim maintenance has been disposed of.
Interim maintenance has been disposed of. So then, as for non-prosecution, CP is pending.
No, my lord.
Then?
My lord, interim application was disposed of and I challenged the same before this honorable.
अरे नहीं अपन CP टा कौन पे फाइल करथिले?
For divorce.
Let me check again.
For divorce, my lord.
CP is pending or disposed of?
My lord, it was dismissed for default and accordingly I have filed.
That's what I am saying. So I have. So
my lord,
you have.
My lord, I have filed a rejoinder, my lord.
ठीक सुनो तो CP the IA arises out of CP. CP is no more there. Suppose I rest. So allow this IA. What order can be passed?
My lord.
Now think about the logic also. Conversely, suppose the CP is restored, you have to file the IA again.
I am praying for adjournment. I will file again.
No. This is not the way to deal with matters.
For a moment, my lord.
Sir, when you are blamed for, we are blamed for pendency of matters, and we keep on pending, keeping matter pending, which is the. Do you mean to say that after restoration this will sort of revive? Automatically.
Well, restoration has already been admitted, my lord. And
you are not answering,
sir.
Sir, please answer the question. By not answering the question.
I'm sorry.
No, why should you be sorry? You are holding a brief, big bold to make statements and make legally nuanced submission. In a CP, you file a IA. CP is dismissed. Now, dismissal of CP is not a res judicata. You can always file IA. Suppose now this IA is disposed of in view of the change scenario. What would be your disadvantage? That I am asking. I am not asking him anything. what you will get out of this pending proceeding. That I'm asking you. That is as simple as
But
that.
I'm challenged that my interim application was allowed from the date of order, my lord.
Correct, sir.
It should be from the
Have
date.
you examined the law on this? You cannot be like a robot. One sentence should not be repeated 10, 20 times because that reduces your submissions, weight of your submission. You are saying that you are agreed by an interim order, passed an interim application, where the CP is no more there.
Restoration is pending, my lord.
Restoration hela pare kon ho pare pachorche apanku kete thara pachari.
My lord, I'll file an accordingly. I'll file an IA for.
So which IA? That will be another IA, not this IA. Sufficient hint has been given to you. And the last occasion also, because they were aggressive actually a little bit, so I just granted you time. Suppose the restoration is allowed. Restoration is for default or
dismiss for default, my lord, and merit matter.
It will be allowed. Then what would happen? You cannot file another IA there.
My lord,
from that date.
My lord, since 2023, the matter is pending and the same is lingering.
Support your submission. Don't give a speech here.
No, my lord, with respect, my lord, with respect.
Sir, make something submission relevant to the case. In the application where you filed your application under which provision?
13(1) before the trial court, my lord.
13(1) what maintenance can be done?
No, my lord.
Sir, again you have missed the point.
My lord, section 24 for interim.
Section 24 interim maintenance. Can you read 24? अरे सर এটা কোন নিরব পঠন এটা কোন ক্লাসরুম না কোন what you are reading how I will know can you read it
Section 24 wherein any proceeding under this act
you have missed a crucial part
maintenance pendentillate and
so pendentillate is what
section 20
meaning কোন it's a Latin term pending litigation
okay
maintenance pending litigation so which litigation is pending now you must understand what you are I mean what my order will look like. How can I pass an order in a disposed of petition on the specious ground that a restoration is filed? Today I will allow your application. Which litigation is pending to make it maintenance pendentillate? Because this proceeding is again section 24. This is not beyond 24. Please appreciate that. So that I wanted to ask from you and again, so kindly then read further.
Wherein any proceeding.
So kindly stop there. Which proceedings? Kindly read further.
Wherein any proceeding under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceeding, it may, on the application of the wife or the husband, order of respondent to pay to the petitioner the expenses of the proceeding.
Which proceeding?
My lord, respect, I understand my same as dismissed, my lord.
What about pending? Pendente, light? Can this court alter what you are suggesting? If I, according to you, if I start reading, maintenance pendentillate and expenses of proceedings disposed of. Now you have started reading wherein any proceeding either pending or disposed of. Those words are not there, sir. You must understand that. So, I mean, you will make my look a laughing stock.
No.
Obviously, I get persuaded. I am impressed by your submission because it is restoration is filed, though it is dismissed, no case is pending. And that restoration is not a case pending as far as this section is concerned. That what is also crucial. wherein any proceeding under this act, that you must understand.
Thank you.
Then kindly read further.
Wherein any proceeding under this act, it appears to the court that either the
Not from the beginning. Leave the court. Then we are running short of time.
my lord,
It may, on the application of a wife or the husband, order the respondent to pay the petitioner the expenses of the proceeding.
And month.
You are adding that the expenses of the disposal proceeding. That is. So, in fact, you are completely distorting that sort of a submission distorts this section 24. That cannot be done. Then provided just read. Then you will further understand.
Provided that the application for the payment of the expenses of the proceeding and such monthly sum during the
proceeding. Again, problem. That you are reading after disposal of the proceeding. Then kindly read further.
As far as possible, be disposed of within 60 days from the date of service of.
So now, what is pending to be disposed of within 60 days? So obviously, it means during pendency of the proceeding. It cannot be. And now, is it that you are remediless for getting maintenance?
And he has not paid a single pay till date, my lord.
Correct. You have helped him by filing RPFM.
No, my lord, no.
Yes. You should have filed execution.
And the wife not.
So you see, the lack of legal strategy is one thing. Adopting wrong legal strategy also a problem. Both are complicated here. So obviously you have other remedies. So now suppose why the law is that you can have recourse to 125, now 144 BNSS. Domestic violence also, financial assistance. And you can execute that decree for the period it has remains decided. So the execution is post disposal or before disposal?
Post disposal.
Then you have yourself created the situation if you have a decree which in your favor. Maintenance penalty here is not allowed or allowed.
Allowed. 7,000 per month.
7,000 per month. So that who has challenged?
My lord, wife.
For enhancement.
Enhancement and for second prayer, my lord, it should be from the date of application. Filing of the application.
So what prevented you from executing that? By taking a leave the day you should have filed this application here. It is filed pending since
21/9/2023, my lord.
23 since 23 it is pending for last 3 years.
My lord.
So that you have helped him. Now what has happened? Because of pendency of the APFM, it could not have been executed. On the first date, you should have taken the liberty from the court to prosecute the execution. So that is part of the long legal strategy. And here it is a lack of strategy that after dismissal, you are following a section 24 application.
I only pray for one adjournment so that, my lord.
How many adjournments? I have been granting you adjournments.
My lord, for a moment, man. In the last occasion, Lordship has only adjourned this matter, my lord. But
so now suppose it is restored. So is it that 24 will not be allowed again? Can you not file a 24 application in an application? Pending application. That is how I say that you taste the logic also. This is no way prejudicial to you. Anyway, you are insisting so much. Anyway. You are Mr. Ramesh Chandra.
Bikram.
Mr. Bikram Swami for the petitioner. Mr. Apaganata?
Soma Patnaik.
Aparna Soma Patnaik, no, sir.
Debesh Kumar Jana.
Debesh?
Kumar Jana.
Mr. Debesh Kumar Jana on behalf of MS Soma Patnaik for the opposite party. The learned counsel for the petitioner was heard at length. Earlier, after hearing the learned counsel for the parties, by order dated 12/1/2026, it was noted that the order of dismissal of the CP 55 of 2021 on 19/8/2025 was sought to be reconsidered before the learned trial court by filing an application for restoration.
Well, same was admitted, my lord.
ଏଥିରେ admit ହେବାରେ କ'ଣ ଅଛି?
No, my lord. Before trial court, my lord, restoration has
Admission is something different.
Sorry, my lord.
It is a IA. There is nothing to be admitted. କ'ଣ ଲେଖିଲେ? ହଁ. Their notices have been issued or what?
Yes, my lord. They have already appeared, my lord.
In the said restoration application, the opposite parties have appeared. Hello? Para. Regarding the provisions of regarding the scope of section 24 of the Hindu Marriage Act, 1955, the Learned Council was heard at length. T6 further adjournment. List in the week commencing.
My lord, 3rd week of March, my lord.
23, in fact, 23. Upon date केबे अछि?
My lord, on 7/3/2026.
Okay. It should be date after that date. 23rd, 23. Yes. Yes, next please.
49.
Published, my lord.
I may please your lord.
Yes,
I.
Yes, I matter.
Yes, ma'am.
So why are not issuing an amnesty notice?
Can be.
Yes.
By amnesty scheme.
Yes.
Amnesty notice is there.
Yes, my lord.
So you have filed it.
My lord.
The amnesty notice was there with the writ application annexure or
No. They have recently by 10/12/25. The address.
They have kindly see the addressee. Who
addressee? We are addressing.
So then file it with a memo. Kagaz diyo. File it with a memo.
I will file it.
Mr. Pragyananda Patnaik for the petitioner. Mr. Satyanarayan Mahapatra. Sir, you are standing counsel.
No, I am counsel for the corporation.
Achha, counsel for the
opposite for no 3 and 4.
Mr. P.K. Sahoo. OP1 kuade gale. Union of India kon ke tan aji binan. OP1 none. Mr. P.K. Sahoo, additional standing counsel OP2. Mr. Satyanarayan Mahapatra for the OP number 3 and 4. OP5 and 6. Notice ହେଇଥିଲା? Bank को notice ଯାଇଥିଲା?
ଆଜ୍ଞା appeal କରୁଛନ୍ତି.
OP5 and 6 none. The Learned Counsel for the petitioner files memo of date, including therein the letter
Communicated by the.
ଆପଣ ମତେ କପିଟା ଦିଅନ୍ତୁ ସେ ଲେଟରଟା ଲେଖିଦେବେ ପରେ।
Yes, sir. Yes, my lord. I am handing it. Later on, by memo, I will find it.
ମେମୋଟା ଦେଇ ଦିଅନ୍ତୁ।
ଆଜ୍ଞା।
କ'ଣ ଲେଖିଲେ? Photocopy of letter dated 19/12/2025 issued to the petitioner.
Petition farm.
Petition of farm.
Yes.
It's a limited liability farm or?
It is a transfer, my lord. I am not gone.
The subject being quote कर देबे amnesty scheme हमको पूराटा लिख देबे amnesty scheme to नहीं की regarding पर्यंत. The memo is taken on record. এটা ଆପଣ receive କରିବେ ହେଲା. I'm passing a common type of order.
Yes, ma'am.
By mentioning that there you are encouraged to arrive at a settlement.
Yes, ma'am.
And Mr. Mahapatra, kindly, I have been requesting Mr. Ray also that all matters you issue amnesty because it is the nature of compliance.
Yes.
It can be worked out.
Yes.
And if the industry survives,
yes,
it is better for the all the employees working.
Benevolent.
Yes. Next, please.
My lord, I will.
29 non-appearance like.
Lordship, you will keep it in record and to that effect with a memo.
देने से मेमो लिखिबे दियो. So 4:15 ପରେ non appearance କରନ୍ତୁ. ନା blank ଛାଡିବେ. ଯଦି ଆପଣଙ୍କୁ appearance ଦେବେ କହିଦେବେ ଆଉ.
ଆଜ୍ଞା.
Yes. For memo type date you Mr. Patel. Yes, next.
Item number 30, I am appearing for respondent wife, my lord.
So Rajiv Bihari Mishra.
My lord.
But petitioner is not there, already time is over.
Yes, ma'am. Short date, my lord.
So since the rest of the matters are for only for admission hearing, hearing matters, you take date.
Item 31, I am for the opposite party.
Yes. You want a date, particular date if you like.
File the objection.
No, I have not touched it. It will be simply posted to some other day. By that date, you complete whatever pleadings you want. Yes.